Your Lordship. Lordship, this matter is a matter arising out of matrimonial dispute, my lords. We have accordingly settled our disputes, my lords, and therefore we want to withdraw this case, my lords.
Okay. Heard,
There is a
mister. Your name, please?
M. Burman, my lords, and there is a stay order dated 3/9/2024, my lords, that may also be vacated.
Learned counsel for the
M. Burman.
petitioner. And Mr.
I am from the respondent, RPC.
RP Singh, learned counsel for the respondent. It is submitted at the bar that being matrimonial dispute, the parties have settled the same amicably and they are not willing to pursue this matter. And accordingly, it is right for allowing the parties to withdraw the same. They are allowed. This civil revision petition number so and so stands disposed of on withdrawal. On withdrawal. Interim order passed earlier. Stands vacated.
I'm so obliged, my lords.
Daily list, item number 1.
May I please, Your Lordship, my lord, I beg to mention for purpose of a time being, my lord. Hello.
Item 2.
May I please, your lordship.
Yes.
Civil revision petition against the order dated.
Page number 44, your lordship. Against allowing the condonation of delay petition. I'm here for the even though I'm petitioner here, and in that case I'm the opposite party, and in the previous suit I'm the defendant. So there was the suit was dismissed because of being time barred. And for filing the miscellaneous appeal, they came after 198 days. So I objected to that by filing the objection petition to the petition for condonation of delay by the ground given there was sickness. It is if sickness of such intensity, it is a sufficient ground by itself, your lordship. But here in this case, the ground actually is not the sickness. The ground itself is page number 37. May I read? In there for this one petition. Actually, this is the ground, not the sickness. Page number 37, page para 2. That the petitioner appellant respectively states that petitioner appellant is a company incorporated under the Companies Act 1950 and is mostly present in the North Indian region of India. However, due to involved in transportation and logistic business throughout India, the petitioner appellant is having limited business and associates employees in the state of Assam, and accordingly, while designated the authorized representative of the petitioner appellant, the petitioner proposed and nominated present authorized representative Sri so and so, who is a permanent resident of Gauhati and is well conversant with the facts and circumstances to pursue the money suit till its finality. So that is the reason. That is the reason actually why we have limited business. We need a source of business. That's why we could not replace when the sickness of the our representative to file the appeal came in. That is the ground which they gave actually. And the person, according to the medical prescription, the representative was ill. Some skin ailments happened, but the other party they knew because he's been sick for the last 2 years. That means since the year 2020.
Okay, let notice go at this. Heard Mr. Nazari, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 5/2/2026 passed by the learned district judge Kamrup M. Gauhati in Mijje case number 77 of 2024, arising out of miss appeal number. What is the miss appeal number?
It's appeal number 77. It is similar with our
77 of 2024. Whereby the learned district judge Kamrup M. Gauhati has condoned the delay of 198 days in preferring appeal against the decree. Judgment and decree dated 11/3/2024 passed by the learned civil judge senior division number 1 Kamrup M. in Mijje case number 106 of 2023 arising out of money suit number 113 of 2020. Peruse the petition and the documents placed on record and also peruse the impugned order dated 5/2/2026, passed in major case number 77 of 2024. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Interim period of the petitioner will be considered on next returnable date. List after.
Highly obliged, your lord.
Second three,
May I please your lordship, my lord? My lord, this is a case, my lord.
Another petition is filed in this matter.
Yes, my lord, he appears, my lord.
Do like this one, he for the decree holder.
Mm.
I am for the judgment debtor. I am agreed by that part of the order by which, although the court admits that I have to get 50% share, but since the land is under bushes and swampy, I wanted a digital survey. Court says there is no provision in this CPC for such survey, so I am disposing. So I am agreed by that part. My learned friend is agreed by another part. According to them, there is a money decree also that has been settled. In fact, I have also a similar grievance against this order because this court earlier, the executive court earlier on 4th of October 2024 passed an order that as far as money claim is concerned, we are just keeping it aside for the time being. We'll take it up at a later point of time. Now, court somehow forgot that order and disposed of the entire proceeding. And what I suggest to them, my lord, I have not got their copies. He has not got our copy. Let us exchange copies and lordship will fix on the next week 18, so that both the petitions can be taken together for motion. Possibly
But then
not
I have an urgency, my lord, because after this partition of the lands, my lord, because that monetary part is yet to be settled, my lord. An amount of around 20 to 30 lakhs odd is due to me, my lord. So that, my lord, to protect that interest, because this, my lord, the judgment debtor, my lord, he says that he has no means to pay the money, and my lord, he says he has nothing. So, my lord, to protect that, at least, my lord, this, the property which has been now, my lord, partitioned between the parties. So, my lord, there may be a restriction on creation of any third party rights or transfer of the property to somebody else. So that ultimately, if, my lord, some money is found to be due to me, my lord, it will only be recoverable from the, my lord, the property which has now been partitioned and handed over to his share, my lord. So until that happens, my lord, otherwise, my lord, the decree, my lord, it will remain infructuous, my lord. That part of the decree, my lord, because the executing court, my lord, cannot, my lord, go beyond the decree or, my lord, because it was not in parts. It was a simultaneous direction, my lord, if your lordship is, my lord.
All the matters together after we exchange copies, or if your lordship now take.
No, he should not be aggrieved by that because it's a innocuous prayer, my lord.
Serious objection.
No, if he has serious objection, he should have come by way of a caveat. In item number 3, my lord, he doesn't have a caveat, my lord. Where is his right to address the court,
Now
my
I
lord?
got instruction to appear, my learned friend has just now got a phone call that we have instruction to appear.
Then he let him argue then. If he has
I'm-
knowledge, he could have
I'm-
obtained the copy. He could have given a notice to me saying that, my lord, he intends to appear. Let me have a copy of that. I would have given him a copy, my lord.
My lord,
Then
let me
let this be heard.
argue. Please argue your
then-
case.
then
I'll argue.
Definitely.
Please argue. And without copy, I can argue because my lord.
No, Mr. Chaudhary,
My
you
lord.
see, in this petition, you have challenged 3 orders.
My lord.
The first order you have challenged here,
Yes, my lord.
it is
Order dated, my
before
lord.
more than 90 days
Yes, my lord.
ago it was passed.
My lord.
There is no condemnation petition for delay.
In this CRP, my lord, to the best of my knowledge, my lord, for the purpose of preferring a CRP, my lord, there is no question of limitation because it is under Article 227, my lord. The question
Is it?
yes, my lord.
Is
The
it?
question of limitation doesn't come in, my lord.
Is
And
it?
yes, and because, my lord, all the 3 orders are, my lord, interconnected, my lord. Because it is interconnected, my lord, that is why all the 3 orders have to be brought. Because if
No,
I
maybe.
only brought into record, my lord, the order dated this, my lord, 18/12/25, my lord,
Mm.
without bringing into record that order dated 4/10/2025, my lord, this, my lord, would not have clarified the position, my lord. That is how, my lord, I have brought it on record. Basically, the challenge is to the order dated, my lord, this 18/12/2025, where, my lord, without taking that effect of the decree into consideration, my lord, the learned trial court holds that the execution of the case is complete, my lord, without taking into account that monetary part, my lord. So, my lord, how the monetary part came into being,
how it is also a part of the decree to bring it to the knowledge of the court, my lord. These two orders are necessary, my lord. That is how these orders are there before your lordships, my lord. Because if your lordships kindly turn to page number 37, my lord.
Mm. No, that's all right. That decree is there.
Yes, my lord. So, my lord, now, if your lordship now kindly comes to the order dated 1812, my lord, lordship will see, my lord, without taking into account that part of the decree, my lord, the court says, my lord, that the case is, my lord, complete, my lord. That is where my grievance lies, my lord, because I cannot be deprived of my monetary dues and share, my lord.
Mm.
That has been given to me by the court and that is not under challenge anywhere, my
No,
lord.
no, the last order being challenged in this petition is all right.
My lord.
But the question is whether in a petition under Article 227,
My lord,
the period of limitation does not arise.
my lord.
Is it?
My lord, to the best of my knowledge, my lord, I respectfully submit, my lord, that the question of limitation is not there, my lord, in 227, my lord. And that also basically, my lord, now that is only to bring to the my lord, knowledge of this court the other orders, my lord. Basically, what is under challenge is that 1812, 2025,
No,
and that is,
without challenging that order also, you can
my lord,
brought it to the
My
notice of this
my
this
lord,
court.
my lord. But that can be, my lord, that at the time of argument of this case, my lord, that can be taken care of what I press, what I do not press. But at this stage, my lord, at the motion stage, what I want to bring to the notice of the court is only a limited thing, my lord. That is, my lord, that this is the decree and this part of the decree has not been satisfied, and without satisfying that part of the decree, the court says the execution part is over. Only on that, my lord. That is why I say, my lord, I am not saying that you, my lord, do away with the set aside the my lord partition or whatever. I only say, my lord, that until and unless this monetary part is settled, my lord, that, my lord, the property which has been partitioned in favor of the, my lord, judgment debtor, my lord, that, my lord, should not be, there should not be any third party rights, or the property should not be alienated, my lord. That is to, my lord, stop multiplicity of proceedings, my lord, at a later stage, my lord. This is only my prayer before the court at this stage, my lord.
No, whether if we postpone the matter
My lord,
till next week,
my lord.
and if we fix both the matter together and
My
hear the same, how prejudice will be caused to you? Whether
My lord,
within a
because
period of 1 week they will alienate the
My lord,
alienate the
what
land?
happens is, my lord, what happens, this is a question of alienation and transfer. Every day counts, my lord. In fact, every hour counts. At any point of time, my lord, there can be a transfer. At any point of time, my lord, there can be alienation. At any point of time, there can be a change in the nature and feature. I say, my lord, I bow down to your lordships, my lord, version that, my lord, what problem it might cause. But what happens is tomorrow, suppose, my lord, there is a valid decree in my favor and a partition being done on the basis of the direction of the court, my lord, and I am in possession of the part of the land. Now, suppose for the purpose of selling it out to somebody also, my lord, there is something.
You say the other side is also present before this court.
Yes, my lord.
So
What is his
Mr.
problem, my lord?
Majumdar,
If, my lord, that part is not given, if he is not, because I am not challenging that whatever, my lord, partition has taken place, whatever shares has been given to him, I am not challenging that. What I am challenging is that, my lord, the monetary part which was given to me by the decree, which is now, my lord, in an entitlement to me, my lord, that has not been taken care of.
No,
And, my lord, it
that's
is on
okay.
record. Let
Yes.
him say that is not on record, my lord, that he says, the judgment debtor, he says that I do not have any money to pay, I do not have anything else. Because he says that, my lord, ultimately what will be recoverable, my lord, will be recoverable only from his share of the properties, my lord. So if he sells that
all
also
right.
transfers, my lord.
Mr. Majumdar,
Yes.
is there any chance of alienating the properties by next week?
May I make some suggestions? The argument my learned friend is making is that there is an apprehension that whatever land I have got
Mm,
in execution of that partition decree,
mm,
there is a apprehension of I alienating that property.
mm.
My lord, this is the ground on which they have deprived me of my 50% share. Earlier, what had happened, my lord,
Mm.
after the decree was passed, the matter went to collector. The collector, instead of partitioning the property in 50 equal share,
My lord, instead of, my lord, all this story, my lord, let him
Sorry,
just
please.
simply, my lord, respond to your
Sorry,
lordship's
please,
query and
please.
say, my lord, that, my lord, he does not intend
No,
to alienate.
let
Why
him
doesn't say it
complete.
in a line, my lord?
Okay.
my lord, let me submit my.
Hmm.
Shouting will not do.
No, shouting will not do for you also. You are interfering when I am moving my
No,
petition.
Mr. Chaudhary, please. Yes.
My lord, this was the ground on which I was deprived of my 50% share of the land.
Mm.
Then the matter went from the ADC, matter went to the Board of Revenue, then to single judge. All the courts, this collector, the Board of Revenue, the honorable single judge passed the same order. This was set aside by the division bench of this honorable court, which I have annexed in my petition, my lord. And this honorable court, the division bench has passed a specific order. Please execute the decree through the collector, taking into consideration Order 20 Rule 18, which says, and read with section 54 of the CPC, that you have to partition the property in 2 equal shares.
Mm.
So far as the monetary claim is concerned, my lord, very interesting. They have gotten an order from the collector that, see, I owe 23 lakhs. There is a decree for 23, which my learned friend is again submitting. There is a decree for recovery of 23 lakhs. And please adjust that 23 lakhs from the share of land I should get.
Mm.
Now, decree I have annexed here.
Mm.
There is nothing like 23 lakhs decree in the decree, my lord. Nothing. And they consistently argue that there is a decree of 23 lakhs. My lordship, may kindly have a look at the decree in my lordship, kindly take out item 5. They have not served the copy of this, despite being informed. And lordship, may kindly take
No,
out.
no, don't say that. When did you inform me that you were appearing
Now,
in this case?
after I appear to be, I
Okay.
say that let it be taken up on a subsequent date after we exchange the copies. That you are not agreeing. My lordship, may kindly see page 24.
Yes, in the impeachment judgment,
Yes, trial court judgment.
order.
Yes, trial court judgment in decree of 1989. my lord.
Yes, yes.
My lord, let my learned friend point out from here, where is the decree for 23 lakhs? And this is the ground they have been consistently arguing before the executive court, before the ADC, before the, my lord, Board of Revenue, before the honorable single judge. And this argument has been, my lord, thrown away by this division bench of this honorable court, which I have annexed here. And today again the same argument is being made. Where is the decree, my lord, for 23 lakhs? Where is the decree? I'm just asking myself, my lord. There is no decree for 23 lakhs. And now they say, reduce your share of land from 50% down to, my lord, there was 18 bighas of land in the schedule. Out of that 18 bighas, my lord, the collector, because of their objection, gave me only 2 kathas. And remaining land had been given to him. Assuming the power of adjusting, lordship, may kindly have a look at the order passed by the Land Tribunal, page 38. The fallacious argument, my lord, that there is a decree for 23 lakhs. I have annexed the entire decree. There is nothing. Page 38, lordship, may kindly see the decree.
Yes.
Suit decreed on contest with the cause against the person. It is directed to make partition of the suit property select by late Sardar Sujan Singh after his death equally between the plaintiffs on the one hand and defendant number 1 on the other hand, taking into account of the alleged property sold by both the parties as alleged, and defendant number 1 is directed to render a true and proper accounts of joint family properties of parties, including the Jyoti Cinema Hall since 28/11/1969, date of death of Sardar Sujan Singh, and to make payment of the amount due to the plaintiffs after proper accounting. So accounting will be done when I serve accounts. This was the order. Now they have been impressing upon the ADC, the Board of Revenue, and the honorable single judge that there is a decree of 23 lakhs. Where is the decree, my lord? Even today this argument is made. Let him show one line from the decree that there is a decree for 23 lakhs. I'll withdraw my petition, my lord, just now. This kind of fallacious argument will not help my learned friend. Why does he make this argument when he's a senior counsel? 23 decree of 23 lakhs, kindly ask them not to sell the property, not to create third party, because I am entitled to 23 lakhs. Where is the decree? Why do you make this argument? Let him show me from this that there is a decree of 23 lakhs. Consistently, this argument, false argument, has been being made. Kindly show me from this decree that there is a decree of 23
Mr.
lakhs.
Majumdar, let notice go today.
Yes,
We'll fix the matter on next day,
yes.
My lord,
next week.
my lord, let me, my lord, react to my lord what he says. When he says that I have been consistently arguing that there is a decree of 23 lakhs, my lord, let him substantiate that I have ever made a statement. I said that money and odd is due to me. on the basis of some finding given. I have never stated. Had I stated that there was
talking
this
about the
detail,
party-
no, don't
party
speak
has
now. When
stated.
I am now arguing, you don't speak. My lord, if that was the reason, I would not have brought this decree and the judgment on record. Can he say, my lord, that he, after continuing the possession of the Jyoti Cinema Hall since 1969, had he rendered a proper service of accounts to the court, my lord? That was his duty to do so, my lord. He has not done it. My lord, it was the assessment of the ADC at some point of time. He says, my lord, I have argued before the, can he substantiate all these things? When he attributes something to me, my lord, when he attributes imputations to me, he should know that four fingers are pointing to him also, my lord. So just saying that I am making a false submissions, that doesn't hold in water. My lordship knows what type of submission I make. Whether I try to get away in the court by making a false submission or anything, my lord, that your lordship also seen me throughout the years, my lord. So it is not a case. The case is that, my lord, what I am submitting before this court is that, my lord, the decree is in two parts, my lord. It says about the partition of the lands, the share of the lands, as well as the money, my lord. Now he says, my lord, it is an admitted position that he was running the cinema hall since 1969. And since 69, my lord, he has not given the, my lord, that accounts, my lord, to the court, my lord. He has not given the total and current account, my lord. And on the basis of the, my lord, assessment done by the ADC at that point of time, my lord, it was, my lord, found out that this amount of money is due, my lord. Now that finding of the ADC, it was not set aside by the revision bench, my lord. What was set aside by the revision bench was that, my lord, the ADC, the decree did not contemplate the ADC to come to that finding. And as such, my lord, that finding of the ADC was beyond the parameters of the writ which was given to the ADC, that was set aside. And therefore, the matter was again remanded back, my lord. And all along I am saying, my lord, that my lord, grievance is not with the partition. My grievance is the business, my lord, the part of the profits of the business that was controlled by him. I am entitled to that, and that was the entitlement given to me by the decree, my lord. Now, if your lordships kindly see, the query of your lordships to him was whether, my lord, there is any chance of, my lord, this alienation of the lands if this matter is taken up after 1 week. He does not answer that. He weaves a very long story, my lord, here and there, my lord, in putting imputations to me, my lord. But he does not answer that query. That is why I stood up and I had, my lord, addressed this court saying that let him answer that query. If he says, my lord, that there is no chance of alienation in 1 week, my lord, I will remain silent. I'll request this court, my lord, to record that, my lord, and I'll sit down, my lord. And whatever order your lordship passes, my lord, I am bound by that, my lord. But he doesn't say that. That is why I am saying, my lord, the apprehension that every hour, my lord, not every day, every hour there is an apprehension that there might be a third party right. There might, these lands may be alienated, and after that, my lord, there will be a multiplicity of proceedings, my lord. Lordship will kindly see both these parties, my lord. This lady, she is in her late 80s, and this gentleman, my lord, the respondent, he is also in her late 80s, my lord. So, my lord, what time do they have, my lord? So let it be settled like that, my lord. If he himself comes forward, if he appears to be so, my lord, wide-hearted, my lord, let him come forward and say that let us sit together tomorrow, my lord, that whatever is due, my lord, let us leave aside the accounts. Let him come and say that, okay, I have been running in from 1969 till the day it was handed over in receivership. Till then, my lord, whatever was there, I offer you this lump sum amount of money. Whatever is there, I will give it to you. Let him say that. Why doesn't he say that, my lord? That is why I say, my lord, there is some apprehension on my part, my lord. And what I am asking for, my lord, I am only praying, my lord, that alienation or change in the nature and feature of the land or transfer may be stayed, my lord. That is all I am asking for. I am not saying that, my lord, don't let him allow into the lands, set aside his partition, set aside the share given to him. I am not saying that, my lord. That is all I am saying, my lord.
Respond, my lord. This kind of order in a proceeding under 227 or 115 cannot be passed in this case. Because, my lord, as far as money part is concerned, my lord, let me clarify. Yes, the Jyoti Cinema Hall was there, which was the suit property, my lord. I have to render accounts of Jyoti Cinema Hall. But division bench has also mentioned that they were appointed a receiver of Jyoti Cinema Hall. So, under Order 20 Rule 3, they have to render accounts. So, both the parties are required to render accounts. Now, I have to render accounts to show that what was the profit during the time the cinema hall was operating. You have to render accounts because subsequently you were appointed receiver. I'm also saying, my lord, that impugn order is bad because this part of the matter was not taken into consideration by the executing court. That is why I have challenged. Partly I am agreed by that part.
Kindly, my lord, record his statement that, my lord, because I was also appointed a receiver, my lord, I was also to render, my lord, accounts. And my lord, what was the condition in which I had received the cinema? That is also in my lord, records in the, my lord, in the TCR, my lord. The wonders.
Okay, okay.
Well, one-
Okay,
Yes, Lordship, let us exchange the copies.
Yeah.
Lordship will take it on the next week. But one submission I have to make today itself, that so far as the final order of 18/12/2025 is concerned, revision under 115 will lie. But so far as earlier orders are concerned, revision under order section 115 of CPC will not lie. It will be 227. My learned friend cannot challenge all the orders in one single petition. That is my submission on maintainability of petition. Your Lordship had initially pointed out. Final order, because it is amounts to disposing the entire proceeding. So 115 petition will lie. About against the earlier orders.
that's all
112
right. Mr. Mazumdar,
Right.
is there any chance of any amicable settlement between the
No,
parties?
my lord.
No.
Because my lord, so far as my client is concerned,
Mm.
he has been rendered a school bus driver. His father left behind 18 bighas of land in Gauhati, including major portion in Gauhati town. They have been depriving him. Ultimately, during the last litigation, my lord, this repeal and all, I had to do charity because he said, I cannot spend anymore. I did charity, my lord.
My lord, let this statement also be recorded, my lord, and tell it when the TCR comes, my lord. What was his statement there and today what is his statement, my lord? Kindly record it, my lord. This is my humble prayer, my
My
lord.
submission is
And the
let us
statement that, my
exchange
lord, I
copies.
have rendered him to be a, my lord, handyman or whatever, my lord, I have rendered him, my lord. Kindly record that also, my lord, and let the TCR come and lordship will see, my lord, what has happened, what is there, my lord.
He is still a school bus driver, my lord. And his father
Kindly
left
record it,
18
my lord.
bighas of land. And because of their objection, my client got 2 cutters and he has got 17 bighas and hot. This was the order which I had to challenge before the Board of Revenue. Board of Revenue did not agree. Then I came before this honorable court. Honorable signature did not agree. It was only the dividend bench who interfered. Anyway, Lordship may fix a next week in the next week.
But till then, this alienation part,
I am not alienating. Where is the question? I have got no intention of alienating.
Record that, my lord.
My lord, my
Kindly
submission
record
is-
that.
My submission.
I am
is-
happy with that. Kindly
my
record that,
submission
my
is
lord.
This kind of order, your lordship doesn't have power to do this, my lord.
no, that's all right.
My
That's all
lord,
right.
any-
Now,
my lord,
he will
has
teach your lord,
rendered a
he will
I have-
teach your lordships what power your lordship
My lord,
has, my
my
lord.
lord, just 1 minute. Supposing, my lord, after both the parties render account, I am entitled to 10 rupees, he is entitled to 20 rupees. Why should I be deprived of my right to deal with my property, which is in lakhs, because of this small amount? We do not know what is the accounts, my lord. Both the parties have to render accounts. On an apprehension that they are entitled to 23 lakhs, which they have been able to, my lord, earlier satisfy the ADC. There is no, my lord, there is no finding before, there is no material before the court that how much of money who is entitled. Today, my lord, on the apprehension or on the presumption that he may be entitled to more, I may be entitled to less, some court may not pass any order, my lord, against me. Lordship may take it up in the next week. Lordship
Let him
can-
say, my lord, that even if I am entitled to 1 rupee, he will save some property, my lord, and give me 1 rupee out of that, my lord.
And this kind
It
of
is not
order-
fine. It
Hey,
is not,
Lordship is
it
not
is
taking
every,
up the matter.
my lord, it
Let
is
us
not a
have a
fun for
copy.
anybody to litigate,
that
my lord,
kind of
since
order-
1989, my lord.
The serious objection, my lord. That kind of order cannot be passed.
Ah.
Although I have got no intention, still I am saying, my lord, that kind of order he is not entitled. Lordship may kindly look at the order passed by the court below.
Hmm.
Court below has passed an order disposing of the, my lord, execution case. How does it say, petitioner, that no, court, if before the court below, I have satisfied that I am entitled to so much of amount. There is nothing, no discussion. Court is simply
Okay,
disposed of.
let us fix the matter in the next week.
Yeah.
On that day, we'll finally hear
Yes,
and
ma'am,
dispose of the
that's
matter,
fine,
entire matter.
Till then, no alienation, my lord.
No,
No,
Well,
man, that kind
No,
of
no,
order cannot be passed.
otherwise your lordship has heard, my
Serious
lord.
objection.
Because, my lord, even to your lordship's, my lord, pointed query, my lord, there was no reply. And he says now,
I have
why,
a serious
why
objection.
this court will stop him, my lord? He says that. So by that also, he says, my
No,
lord, that my apprehension of being the lands being alienated is correct, my lord.
Lordship will take it up in the next week. Lordship may take up tomorrow also. I have got no difficulty. Day after tomorrow also.
heard Mr. G. Chaudhary, learned counsel for the petitioner. Mr. D. Mazumdar, learned senior counsel assisted by Mr. D. Mazumdar. Learned counsel for the respondent. who has instruction to appear in this matter. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 14-10-2024, 28-2025, and 18-12-2025, passed by the learned Civil Judge Senior Division, Jorhat. It is to be noted here that by the impugned order dated 18-12-2025, the learned Civil Judge, learned Civil Judge Senior Division, Executing Court has disposed of the title execution case number 3 of 1989. 89 on full and final satisfaction of the decree. Peruse the petition and the documents plus on record, and also peruse the impugned order dated 14-10-2024, 28-2025, and 18-12-2025. Let notice be issued returnable on 28.
My lord.
28.
Eight.
Let it be 29. 28, there is one matter, my lord, arbitration matter.
29.
I cannot count.
Mr. Chaudhary, any objection?
No, my lord. No.
29. However, no formal notice is required to be issued since Mr. Majumdar entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Mr. Majumdar submits that the respondent hearing also preferred one civil revision petition number 124 of 2026, challenging the same impugned order dated so and so 18-12-2025. 18-12-2025. And he submits that both the matter may be listed on 29. Accordingly, it is provided that registrar shall list this matter along with CRPIU number 124 of 2026 on 29th, on which an endeavor will be made to finally hear and dispose of both the cases.
In fact, by a very short order, it can be disposed of. So executive court has to simply, my lord, open the matter and decide the remaining issues.
No, my lord. In view of whatever statement he has made today, the TCR, I will pray before this honorable court, my lord, kindly see the TCR, my lord. Then your lordship will determine, my lord, who is fallacious and who is taking this court for a ride, my lord. That is my prayer, my lord.
No, whether TCR will be required.
Yes, my lord. Because he says that, my lord, about the monetary part.
No.
And he says
No,
about,
no,
my lord, that
Mr.
who has
Chaudhary.
been on receivership.
No, Mr. Chaudhary,
My lord.
you say this is civil revision petition.
My lord.
We cannot appreciate that part of
No,
argument.
I don't want to, my lord,
The executing
appreciate
court
any
has
evidence.
to deal with it.
Yes, my lord. I don't, my lord, pray before this court to appreciate any evidence. Just to satisfy your lordships, my lord. Because when he makes this sort of a
No,
statement, my
not
lord, just to
necessary,
satisfy what is there, that is why I've been telling, my lord, call the records and see for your lordships, my lord, own self, what is there in the record. He says, my lord, I have been dragging and I have, my lord,
No.
done something by which
necessary.
you are deprived.
No, not
My lord,
necessary.
for that also, record is not necessary.
Ah.
Writ appellate court, divisional bench of dishonorable court has mentioned that. That is what I am mentioning. I can show for just now, my lord. This 22
Okay, on
months
next
may-
day we will consider.
Yes, my lord.
My lord, regarding that alienation, one
No,
line at
no.
least, my lord.
No,
My lord, why should I be made to
that kind
suffer,
of
my lord?
injunction cannot be granted.
It cannot
My
be
lord.
granted.
Why should I be made to suffer, my lord?
No.
My dues, it is admittedly that I have some
I
dues.
don't think that till next day you will suffer.
Then let there be a next date that will also be considered, my lord,
Which one?
regarding alienation.
No. Finally, we will finally
Suppose it
dispose
is-
of the matter.
Suppose it is not finally disposed. At least give me a liberty to mention it on the next date, my lord.
You can mention it.
Kindly give me that
No,
liberty,
not
my lord.
necessary.
My lord,
But otherwise, what will happen, my lord? Otherwise, what will happen when that sort of a, my lord, when that sort of an observation is not given, what is considered is that, my lord, that is waived. That is we have seen throughout our practice, my lord. Once, my lord, kindly, when an interim prayer is made and that is, my lord, not considered, on the next date, what is, my lord, considered is that, my lord, so that was not considerable by the court, that is not considered at all. So only one line, my lord, that if, my lord, this matter.
Mr. Chaudhary,
My lord.
okay, while we have made categorical observation that on that day we will give final consideration to the matter.
My lord, at any point of time, for whatever reason, it may not also be done, my lord. Just give me liberty to make a mention. Why the liberty, why not?
No, no.
That liberty, my lord, why he's
No, no,
necessary,
no,
my
Mr. Chaudhary,
does he know what is necessary, not necessary, my?
No,
Will
no,
he
no.
guide the court, my
No,
lord?
no, 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 no.
Mr. Chaudhary, do not argue like
No,
this.
no, I am
not
arguing like this.
against- I am
No,
not
no,
arguing
no,
against-
Don't argue. Why you say what is necessary, what is
No,
not?
no,
Will you
no.
teach me?
I
Will you
personally
teach me?
objection. I personally.
Sir, he will not
Chaudhary.
teach me, my lord,
No,
what
no,
is
Mr.
necessary, not
Chaudhary.
necessary. I know what apprehension I am feeling, my lord. That is why I am making a request. Why is making a commentary, my lord?
No,
I have
no.
not been speaking to
No,
him.
Mr. Chaudhary, you see, we have already ordered that on that day we will give a final consideration to
Yes,
the
my
matter.
lord.
If we fail to do so, definitely we will consider your interim period.
That is one line
Not
only. I said,
necessary.
just give me liberty to make a mention. If it is
Not
otherwise, not
necessary.
decided.
I am assuring you.
My lord,
I am
my lord,
assuring you.
I am deeply concerned.
Item 4,
Lord, petitioner's grandfather purchased 9 acres of land, my lord. The land was, my lord, 9 feet by 144 feet. But what happened, my lord? Half of the portion of the land was taken over by somebody.
No, no.
Filed the suit.
I fail to understand
Yes.
why the DAG number, patta number, everything is mentioned in the
Everything
city.
finds boundaries
Then
there.
why the land could not be identified
I
by
do
the
not
Mandal?
understand, my lord. I do not understand, my lord. Everything is there, my lord. And my lord, backside land is there, my lord. 9 feet by 72 feet I am occupying. Front side 9.
Where is the Mandal report?
Mandal report is not here, my lord.
Can you produce it?
If I can produce, my lord, let notice be issued, my lord. Next date, my lord, I shall produce. That will be better, my lord. If other party appears, my lord, it can be disposed of, my lord.
No, no. Without issuing notice, can we not dispose of the matter?
Yes, it can be, my lord.
Can be, but you produce the report of the
My lord.
Mandal
Then in that case, my lord, your lordship may fix it next week, my lord.
next week. Next Monday then?
Next Monday.
Okay. Heard.
My lord,
Mr.
not next Monday, my lord. It may be Tuesday,
Tuesday.
Wednesday.
Wednesday. Heard Mr. Z and Sayola, learned senior counsel, assisted by.
Wednesday. Huh? Oh, I'm sorry, my lord.
Madam, your name please.
S2D.
Learned counsel for the petitioner.
My lord, my lord, it may be on 1st of my lord, May. No, 1st May, holiday.
4th May.
4th of May, my lord.
4th of May.
4th of
Mr. Sayola, learned counsel for the petitioner submits that the report of the Latmandal based on which the impugn order
Yes.
dated 9/2/2026 was passed by the learned executing court has not been enclosed with the record, and he pressed for listing the matter on 4th of May. 4th of May, so as to enable him to produce the same before this court. Parallel basis, I'll list the matter.
item 6. Item number 6,
My senior is coming, Your Lordship.
7,
It's similar. It is similar, 6 to 8, similar.
item number 9,
My lord, on last occasion. My lord, on last occasion, I prayed for some time to get instructions whether the respondent number 3 has been substituted. But what I gather from the order of the Supreme
Your
Court,
item number 9.
item number 9,
Okay.
it went up to Supreme Court. I'm sorry, my lord, I'm not in item number 9, sorry.
item 9,
None appears for the petitioner on call, lays the matter after week.
item 10,
Materials.
Hmm.
In this case, Lordship, I have instituted a title suit in trial court, Lordship, court below. The main contention was that, Lordship,
My predecessor of interest have purchased some plot of land, measuring 9 bighas of land. From the Jugenda Mohan, or namely one Jugenda Mohan Roy. Then Lordship, predecessors being a plaintiff, we are enjoying the land. However, the defendants have encroached the land, some part of land, or some portion of land. Therefore, I instituted suit before the trial court below. Then they have filed written statement. I have filed evidence. They have also filed evidence. And it is the stage of argument. Before the argument, Lordship, argument stage, I have,
You tell me how that deed, sell deed is relevant here.
yes, Lordship, therefore I am going to. Sell this is relevant here because Jugenda Mohan Roy, I have purchased land from Jugenda Mohan Roy.
But you say nowhere in your pleading and in your evidence you have mentioned it.
Lordship, then Lordship, in my plane,
Mm.
it has been stated that my land is belong to Patta number 63, Dag number 63.
Mm.
63, this is the same land, Lordship. This
Mm.
same land has been purchased by them in Jugenda Mohan Roy from the Inda Mohan Talukdar. In my plane, Lordship, pair number 4, and in fact in the schedule, Lordship,
Mm.
all the Dags are mentioned here. All entire lands have been purchased by me, Lordship.
Where is your plane?
My plane, Lordship, it starts from Lordship page number 11, and Lordship kindly see page number 14.
Paragraph number?
Page number 14, Lordship.
Page number?
14, schedule of the land. Page number 14, Lordship.
No. Amended plane start from page number 11.
11, it is for page number 14, Lordship. 14, 1-4.
Yes.
1-4, schedule A land, Lordship.
Mm.
Merit. A plot of land measuring 7 bighas, 4 katha, 4 lessas out of 19 bighas, 2 kathas, lessas covered by Nang number 164, 57, 63.
Mm.
And Lordship, schedule B, 1 bighas of land covered by Dag number 57, 5 feet land in beach covered by Dag number 63. This 63, Dag number 63 has been purchased by the Jugenda Mohan Roy, which has been purchased by me from Jugenda Mohan Roy.
No, in your plane, where is
Yes,
the
plain.
abutment?
Plain, Lordship. Plain, Lordship, para 3, Lordship, and
Mm.
4. That Jugenda and Noyanda out of the land is with Dags and Pen. They sold some lands to some person. Jugenda Sandaran purchased from Inda Mohan Talukdar. The land 2 bighas covered by number 63. By virtue of since and Jugenda took possession of the purchased land, and he got his name mutated by that process in his Inda Mohan Talukdar in the land avenue record. Lordship, by this, Lordship, entire land has been purchased by me from Jugenda Mohan, and I want to show that Jugenda Mohan purchased the land from Indo Mohan. Then what is the infinity that Lordship? Their contention is that land belongs to the defendant. Defendant is encroaching my land, which has purchased from and I have purchased, my predecessor has purchased the entire land from Jugenda Mohan Roy. And Jugenda Roy, where he got his right title from Jugenda Mohan Roy. And at the time, Lordship, it is at the time did sell, it was definitely not with me. At least it is an old document. It is not because I have purchased Jugenda from Jugenda Mohan Roy. And now, if it is fine by me, Lordship, then I want to leave the course before record, and court rejected that no, this is not a required document. Lordship, for a consideration that the land originally belongs to that Jugenda Mohan Roy.
No. Regarding that sell deed, there is no reference in your petition.
That sell deed, there is no reference.
Then-
That cannot be because
Then why the trial court will allow you to introduce such a document at the stage of argument?
Lordship, at least Dag number 63. If Lord trial court sees that where from Dag number 63 is come, Dag number, the land belongs Dag number 63 is entirely from Jugenda Mohan got his title from this sell deed, earlier sell deed. That is therefore our contention is that the earlier sell deed, he has got this Dag number 63 from the earlier sell deed. If suppose tomorrow defendant says that.
Okay, let notice go at this stage. Heard Mr. D. Mohanto, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 24 2026, passed by the learned civil junior division number 1 Nagaon, entitled suit number 335 of 2021. It is to be noted here that by the impugn order dated so and so, the learned civil judge junior division number 1 Nagaon has dismissed the petition filed by the petitioner, being petition number 40 of 2025, filed under orders 7, rule 14(3), related with section 151 of the Code of Civil Procedure. For granting leave of the court to submit the cell deed number 9568 of 1979 on the ground that the cell deed could not be traced out at the earlier stage in spite of several faults. Where is the petition and the documents placed on record? That notice be issued to the respondent returnable in.
Respondent Lordship 1 to 6, Lordship, and Lordship 7, 8, 9, 10, 11, Lordship, they are not contesting this week, Lordship, that may be tackled, Lordship. I have written the pair number 3, Lordship,
Issue to the respondent number 1 to 6.
6, contesting
1 to
dependent.
6. Step by speed post and also by usual process within a week from today. Mr. Mohanto submits that though respondent number 7, 8, 9, 10, and 11 are arrived in this petition, those respondents did not participate in the proceeding. Now, in the title suit number 335 of 2021, and as such, they are not necessary parties in this petition, and therefore, he submits that their name may be struck out from the array of this petition. They are allowed at the cost and risks of the petitioner. Mr. Monto shall furnish the amended cost title within a week from today. At what is this, the case is pending now?
On 30, Lordship, 13 of 30 appeal for
Or-
argument. For argument, Lordship.
Argument.
Argument, Lordship.
List the matter after 4 weeks until returnable date, the impugn order dated further proceeding of title suit number 335 of 2021 stands state.
Obliged.
I make item number 6.
This matter, similar matters, my lord, had disclosed of. They covered.
Right. Similar order on our court.
This is regarding written
Enter.
obligation. My lord, the impugn order and the petition number I have written, my lord, in all the three.
Four orders.
But 6, 7, and 8.
Next slide.
Four orders, item number 17.
Obliged.
Lordship ended was unable to present before this court, but still sometimes. Kindly adjourn the matter for the day.
But what happened in this case, the amount which has already been sanctioned, that has been released, my lord, and received by the petitioner. My further grounds is that as per the direction of this honorable court, the entire payment has not been made, my lord. That's why your lordship has directed to file a detailed affidavit as to why the payment has not been made. Let them file the affidavit, my lord, to that effect.
Okay. Heard Mr. R.S.K., learned counsel for the petitioner. Ms. Anne Fokon, learned counsel appearing on behalf of Mr. Khatonia. Learned counsel for the respondent contender. Ms. Fokon submits that Mr. Khatonia is absent today.
Yes, sir.
Is absent today. And as such, the price for listing the matter. After a week?
Yes.
After a week, parallel, recess will list the matter on. So do you fix it?
So maybe fixed one.
4th of May.
Well, 4th of May, I have some difficulty. After that, well, 7 or
6.
6.
6 weeks.
Okay.
Item number 18.
Well, 8th of May, well, if possible, but I will be out of station, well, for 4.
Okay, 8th of May.
Much.
Sorry, my lord. In item number 18, my lord, respondent number 3, he had expired during the pendency of the SLP before the Supreme Court.
Mm.
And his legal heirs were substituted in the SLP. I got, on last occasion, I was not aware of that fact. And in this present second appeal, the respondent number 3 has to be substituted by his legal heir, that is his wife. This is the order passed in the Supreme Court.
No, that's all right. Whether you have filed any such application here?
Here I have not filed because, but before the Supreme Court already it has been substituted.
No, maybe that is a different proceeding. This is a different proceeding.
Otherwise, also the other respondents were also substituted before the Supreme Court here. I have
Maybe without submitting, without filing an application before this court, can we do this?
that's also the, but it came from.
File an
Supreme Court.
application, maybe.
I'll file a fresh application then in that case.
Or Mr. Thor, learned counsel for the appellant, and Miss S. D. Murtaza, learned counsel appearing on behalf of Ms. R. Chaudhary, learned counsel for the respondent. Mr. Thor submits that respondent number 3, namely Ramendra Narayan Das, has expired on 7/9/2024. And to implement the legal heirs of the said respondent, the appellant herein will file an application within a period of 1 week from today. Within 1 week from today?
Well, some little more time because they hail from Badarpur, Karimganj district. 2 weeks, madam.
Okay. Within a period of 2 weeks, and he price for listing the matter after 2 weeks. Fair allowed, rescission list the matter after 2 weeks.
Your Lordship, I've been led by senior advocate Mr. P.K. Shwari, Your Lordship. His name may be kindly reflected in the
Yes.
cause list, Your Lordship.
No, is it necessary to mention his name here? And it is not reflected in the cause title also, cause list also.
Yes, Your Lordship.
Obliged, madam.
Item number 19.
You are for the respondent.
Respondent, Your Lordship. Respondent number 2.
Appellant is absent today. None appears for the appellant on call. However, Mr. Your name, please?
M. Shah for 3.
M. Sir, learned counsel appearing on behalf of
K. Yadav.
K. Jadov, learned counsel for the respondent number 3.
2.
Respondent number 2. Respondent number 2. List the matter after a week.
Actually, there were 9 respondents. 1 was struck off. So I was in the main petition, I was respondent number 2. Now I'm respondent number 1. Actually, there were 9 respondents. Now,
Okay, respondent number 1. List the matter after a week. In the event of subsequent non-representation of the appellant, appropriate orders will follow.
Item number 20.
in your lordship. Your lordship, pertaining to item 17, your lordship. I'm appearing on behalf of Angie Khatun, your lordship. He could not be able to come today, your lordship, due to yesterday.
No, we have already passed the order. One counsel has appeared on behalf of Mr. Khatonia. Yeah.
20.
Lordship. Respondent number 2 and 3 appeared, your lordship. There is a.
But today they are
Respondent
not
was-
present before the court. Or Mr. Korim, learned counsel for the applicant. None appears for the respondent on call. List the matter after a week.
Lordship.
In the event of subsequent non-representation of the applicant, appropriate order shall follow.
29th of April. Matter number
Respond.
29. Number 21.
Appropriate order.
21.
Here I am from the respondent matter. The office was dated 11/3/2026. Let's say the NCR of items that has not been written. 11/3/2026.
Trial court record has not been received. None appears for the appellant on call. However, Mr. Hawk, learned counsel for the sole respondent,
No, all the rest.
for all the respondents
Main
present.
corporation of this part.
Office note dated 11/3/2026 indicates that LCR of TA number 41 of 2014 has been received, but the LCR of TS number 115 of 2010 has not yet been received by the section till date. Accordingly, it is provided that SSL issue urgent reminder to the learned court below for transmitting the record of TS number 115 of 2010 by special messenger. List the matter after a week. In the event of subsequent non-representation of the appellant, appropriate orders shall follow.
Matter number 22.
May please, your lordship. In this case, respondent had to file their legal heirs, names of the legal heirs, lordship.
But you have not filed the application.
No, he had not provided the names of the legal heirs, lordship. So we are not able to file.
Okay. Is it available with you? Furnish it to him. Heard, Mr.
KD Sharma.
Learned counsel for the appellant, and Mr. M. Rahman, learned counsel appearing on behalf of N. Ahmed, learned counsel for the respondent. The learned counsel for the appellant submits that the learned counsel for the respondent has not furnished the names of legal heirs of deceased respondent number 1. However, the learned counsel for the respondents has furnished the name of respondent legal heirs of the respondent number 1 to the counsel for the appellant today. And on such count, the learned counsel for the appellant press for listing the matter after a week for furnishing appropriate application for implement of the legal heirs of the deceased respondent number 1. We are listing the matter after a week.
Also, one thing is that they had not provided date, lordship, of the disease.
You obtain the date.
Because
Furnish it.
without date of the disease, lordship.
Obtain the date and give him to him.
23.
Lordship, matter may be passed over for the time being. My senior relaxing court number 18.
For the last order, they were supposed to take that step of respondent number 2.
So whether you have filed the application, no, sorry, affidavit.
Lordship, I don't have any knowledge about the case.
Okay, after some time, let her senior come.
25.
May I please, your lordship? Lordship, in this matter, TCR has been received and the service is also completed.
So we can list the matter for hearing.
Hearing, your lordship.
Heard,
Lord-
miss, your name, please.
J. Sharma on behalf of A. Iqbal.
J. Sharma, learned counsel appearing on behalf of Mr. A. Iqbal, learned counsel for the appellant, Mr. Mondal for the respondent. it is submitted at the bar that service in this matter has been completed and the LCR has also been received. And in
Lord-
that view of the matter, the
Lordship may kindly fix a date in the month of March.
bars,
Sorry, your Lordship may.
matter may be listed for hearing. Accordingly, it is provided that LCR list the matter for hearing. On
12 of May.
12 of May.
Obliged, Lordship.
Here appending formula respondent number 2. Here for respondent number 2.
So Mandal for respondent number 2.
Obliged.
26. Number 26.
None appears for the petitioner on call. List the matter after we, in the event of subsequent non-representation of the petitioner, the appropriate order shall follow.
27.
Lordship, here, in the cost title, only the serial numbers are wrongly arranged, so, Lordship kindly, allow us to correct by hand.
Which one?
Only the, in the cost title, only the serial numbers are not arranged in order. In the respondent part.
Where
Page
is the
number
wrong?
3. Page number 3.
Page number?
3.
Page number 6.
3. Lordship.
No, there is a one notification of the registry. You have to file application for. It cannot be allowed by hand. Will be copied too. Pardon, miss, your name, please.
M. Khatoniar, on behalf of DK Das.
Learned counsel appearing on behalf of Mr. B.K. Das, learned counsel for the petitioner. The learned counsel for the petitioner summons that in mentioning the serial number of the respondents, the cause title of the petition, some error has been crafted, and she prays for allowing her to correct the same by hand. However, it appears that already one notification has been issued by the registry regarding correction of the cause title. And in view of the said notification, the learned counsel has to file an interlocutory application to that effect. Accordingly, it is provided that the learned counsel for the petitioner shall file appropriate application to that effect. List after 1 week.
Pardon?
After 1 week.
Number 28.
May it please your Lordship. Your Lordship, in this matter, as per office note dated 6/4/2026, service report is awaited, my lord, and LCR of the title appeal has not been received yet.
So Sutter for respondent number
And for respondent number 2, 3, 6, and 7.
2, 3, 6, and 7.
6 and 7, yes.
Part Ms. Mortaza, learned counsel for the appellant, Mr. Sutter, for the respondent number 2, 3, 6, and 7. Office note dated 6/4/2026 indicates that service report in respect of respondent number 4A and 5 is still awaited. No. Unserved notice issued to the respondent number 4A and 5 return. Has been received by the section. Accordingly, it is provided that the learned counsel for the appellant shall take fresh step upon the respondent number 4A and 5 by speed post and also by usual process within a week from today. The office note dated 6/4/2026 also indicates that LCR of title appeal number 15 of 2020 has not yet been received. Accordingly, it is provided that registrar shall issue reminder to the learned appellate court for transmitting the record of title appeal number 15 of 2020 by special messenger. Registrar shall list the matter after 4 weeks.
Yes, sir. Obliged.
Item 30.
I can take an objection to it. I made a mention in the morning.
Okay. So, ready to argue the matter?
My lord, my lord.
I'm ready. If that objection has come.
Yes.
Beg your lordship, my lord. My lord, this RSA was listed on 13/2/2025, my lord, and which is reflected in page 5, para 2. Then, my lord, the then learned counsel, my lord. I just want to take a lordship to page 9, Annex A. The engaged counsel, my lord, he was admitted to ICU, my lord. Date of admission is specifically written 12 February 2025. And on the next date, this case was listed for hearing, my lord. Date of discharge is 15 February 2025, my lord. And the details is reflected in page number 10. This course in hospital treatment, conservative treatment has been given, my lord. Everything has been written, my lord. I just do not want to take lordship's much valuable judicial time. And on the basis of that, my lord, the Honorable High Court passed an order that at 13/2/2025, page number 16, only the relevant portion I am just reading out for lordship's kind convenience, my lord. None appears on behalf of the appellants in both the appeals on call. Part number 3, taking into account that none has appeared on behalf of the appellants in both the appeals stand dismissed for non-prosecution, my lord. So, my lord, the absence is not intentional, my lord. The earlier counsel, my lord, he was admitted to ICU, my lord. And therefore, we have filed this miscellaneous petition before your lordship for restoration of this to the original case record, my lord. And my lord, now coming to the their affidavit. If my lord, para number 4, page 20 of their affidavit, my lord, para number 4, para number 5, para number 6, para number 7, if conjointly read, my lord, my submission would be, my lord, whatever has been stated, my lord, that section 5 of the Limitation Act, no application has been filed. In absence of any application for condemnation delay, the present restoration application is not maintainable.
Para number 5, the applicant has failed to show any sufficient cause explaining the delay. Therefore, the delay, if any, sought to be explained subsequently is not liable to be condoned. Appeal dismissed for non-prosecution cannot be granted as a matter of course, particularly when the appellant fails to act with due diligence within the statutory period prescribed under Article 122 of the limitation.
What is the period of limitation?
Period of limitation, my lord, we have explained it in our petition, my lord. We just
No, I am asking you, what is the period of limitation?
60
Pardon?
60 days, my lord.
60 days,
30 days.
30 days, 30 days.
30 days.
30 days, my lord. But the question is, my lord,
Here, what is the delay?
Here, my lord, the order was passed on 13th of February 2025, and this case, miscellaneous case, was filed on 7th of October 2025.
After?
After more than 8 months.
8 months.
and which I have explained it in my lord in my application, para 4, which is very important, my lord, para 4.
No, you have explained in your application, but your application should be accompanied by an application for condonation of delay.
My lord, we have not application of condonation as my small brain is concerned, my lord. Application for condonation of delay is not be filed here because, my lord, we got the information, my lord, because when the land counsel was in ICU, my lord, he has left it because
No,
he has
that's
to
all right.
understand
That should have been an explanation in the application.
application, my lord. We have written in the application, my lord. The applicant very recently came to know about the dismissal. That means, my lord, we filed this on, we filed this in October, my lord, and therefore, my lord, that the applicant, part number 4, my lord, page 5, that the applicant begs to submit that the applicant very recently came to know about the dismissal of the regular second appeal, and after that approached the earlier engaged counsel, legal land counsel, and took the brief of the case, and thereafter engaged the present land counsel, that is me, my lord, and after handing over the case files, asked to prepare the present miscellaneous case for restoration of so-and-so, which was dismissed on default by order dated due to non-appearance of the counsel of the petitioner, my lord. I have left it to your lordship, my lord. Any direction that will be given, my lord, I will follow.
Whether filing of separate application is necessary.
My lord, if my dear friend has already completed, let me submit this application is not having maintainable.
Why?
The Code of Civil Procedure specifically provides for readmission of an appeal which has been dismissed for default. I may take your lordship to order 41/19. There is a specific provision under the CPC. Order 41/19. For readmission of an appeal
Order 41,
which has
order
been
41.
dismissed for default, an application under order 41/19 has to be filed. This miscellaneous application is neither filed under any of the provision of any of the law. This is simply a miscellaneous application without citing any provision of law. Moreover, there is no explanation for the delay. There is no separate
No.
application for.
You say, Mr. Dhor, when application is before the court,
Yes.
maybe he has not mentioned the relevant provision of law. Oh, whether non-quoting or misquoting of any provision of law,
Different issue.
yes.
But the
And in
restoration-
the application also, he has mentioned the reason for which the counsel for the appellant could not appear on the relevant date.
And there also I have made a specific amendments regarding that objection also. That person whose name has been reflected in the prescription, he is not an advocate on record for the appellant in that matter.
Okay.
That is also there. There were several other advocates also appearing for the appellants, but this person's name does not reflect in the record. I don't know from where this prescription has come, and this medical prescription, which has been shown as the counsel for the appellant hearing,
Mm.
The lordship record is there. Lordship will see whether this person was the record advocate on record for the appellant or not. The person's name was Hazrat Bhuiya.
উকালৰ নাম কাৰ কাৰ
Hazrat Bhuiya.
উকালৰ নাম কাৰ কাৰ আছে RSA 166
Counsel. Hazrat Bhuiya. He was not an advocate on record for the applicant.
No, Hazrat Bhuiya is there. In RSA number 390 of 2017. His
There
name is there.
Other counsels also. Yes, in the name.
Others are also there. His name is there. So the case was dismissed for default on 13th of February.
February.
And on 12th of February, this counsel was in the ICU.
Wonderful. If he was ICU, then I have no objection, but there were some other counsels also who could have mentioned it before the court when the matter was listed and called for hearing.
No, here it appears that he is the leading counsel.
Even then, it took around 8 months for them to access that.
8 months, so that delay is explained in paragraph number 5.
No sufficient.
Hmm?
That the only line is that recently came to know. That is the only reason. Paragraph 4 is the only reason. Recently came to.
Let us restore the matter.
Discretionary jurisdiction by that and. for
We'll
the-
finally hear the appeal. We allow this application. Heard Mr. Roman, learned counsel for the applicant. Then also heard Mr. Dhor, learned counsel for the opposite party.
There are some other parties also. I don't know whether they are appearing or not. There are other respondents also. Apart from this, I am for respondent number 1 also.
Mr. Dhor, learned counsel for the respondent number 1.
There are respondent number 2, 3, 4, 5, 6.
So 2, 3, and 4
5, 6.
served. 5 and 6 are not yet served.
Madam,
Opposite party number 5 and 6. Respondent, no, notice not yet been served.
and we have taken steps, madam. I do not know. We have taken steps 2 times, madam. We have taken steps, madam.
No,
I leave it to your lordship, madam. I leave it to your lordship.
Heard Mr. S. Rahman, learned counsel for the
I'm SS A Rahman, my lord. SS A
learned counsel
Rahman.
for the petitioner. And Mr. Dhor, learned counsel for the opposite party number 1. Office note dated 7/4/2026 submits that reveals that neither ready card nor unserved notice issued to the respondent number 5 and 6 have been received by the section till date. The learned counsel for the petitioner is directed to take fresh step upon respondent number 5 and 6 by speed post and also by usual process within a week from today. Mr. Dhor, learned counsel for the respondent, for the opposite party number 1 submits that he has filed objection in this application. This is the matter. After 4 weeks,
My lord,
you take step upon respondent
lord.
number 5 and 6.
highly obliged, my lord.
My lord, as per the service, as per the office notice, my lord,
Pardon?
as per the office notice, my lord, office note, the AD has not returned till now.
You offer respondent number 1.
Number 1, your lordship, filed a written objection against the I, which has been text along with it.
Okay.
My submission is that, my lord, the service may be deemed to be completed, my lord,
Pardon?
and the service may be deemed to be completed and the matter may be fixed for objection hearing, my lord,
No.
because more than 1 month have
In
elapsed.
respect of respondent number 2 and 3, service report has to be received, no? Heard, Mr. Your name, please.
M. Pandit.
Learned counsel for the petitioner and Miss.
And thus,
Learned counsel for the respondent number 1. Office note dated 26/3/2026 indicates that service report in respect of respondent number 2 and 3 have not yet been received by the section till date. In that view of the matter, it is provided that recessal is the matter after a week, awaiting service report upon respondent number 2 and 3. The learned counsel for the respondent number 1 submits that she has already filed the objection. And the same is when did you file the objection?
26.
But the same has not yet been placed on record, and accordingly it is provided that recessal list the matter after 2 weeks and take the written objection filed by the respondent number 1 along with the record.
Interim order may kindly be continued.
Interim order passed earlier shall continue.
42,
May I please, your lordship, here might have the record of title appeal has not been received, but there is an order that it's 5/5/2025 that this matter may be heard without the record of the title appeal. So it may fix for final hearing, my lord. Already there is an
No,
order.
This IA is filed for?
The I is filed for order 40 on rule 27, my lord, and that can be decided at the time of final hearing.
Okay.
That is why, my lord, this matter was fixed for final hearing.
Put down in IA, heard Mr. Hawk, learned counsel for the applicant, and Ms. Goswami for the respondent number,
Sole respondent.
for the sole respondent. Sole respondent. This application under
Yeah,
Order
only-
41, Rule 27 of the present table procedure is preferred by the applicant for production of additional evidence. Mr. Hawk submits that this application may be considered at the time of hearing of the appeal. Accordingly, it is provided that recess at least the matter along with the RSA number 92 of 2010. In RSA number 92 of 2010, you take down heard Mr. Hawk learned counsel for the appellant here. Appellant here. And Ms. Usami for the respondent. Mr. Hawk submits that the matter may be listed for final hearing.
Final. Only there is an order 5/5/2025.
Accordingly, it is provided that recess list the matter on
My lord, in the month of May, my lord, any day of third week of May. It is 2010 matter, my lord. 19th of May. 19th of
along with IA number 273 of 2025.
my lord. Obliged. 33.
Lordship, here we have appeared for dusty service, Lordship, but we could not serve the dusty service yet. Today, family court matter was fixed, but she did not appear, Lordship. So, Lordship, I have two prayers, Lordship. The dusty may be there, Lordship, and also we may be allowed to take, Lordship, fresh step through speed post also. And another prayer, Lordship, there is a possibility, Lordship, that address might have been changed, Lordship. We are trying to procure the current address, Lordship. If they are so, that Lordship may allow us to amend the post title and take fresh step to the speed post through speed post, Lordship. Two prayers, Lordship. Dusty may be there and speed post to be there, Lordship. After amending, if there changes of address is there, Lordship, we might be allowed to.
No, first you have to ascertain whether there is any change of address or not.
Yes, Lordship, we are trying to procure, Lordship.
Only thereafter we'll consider your care. Heard, Mr.
Amen, Lordship.
A Mena, learned counsel for the applicant. Mr. Mena submits that affidavit pertaining to dusty service is yet to be filed, and he prays for listing the matter after
3 weeks, Lordship.
3 weeks. After 3 weeks, they are allowed to list the matter after 3 weeks.
All right.
34. Well, this is IA for early hearing. It is a case of 2011, my lord. Any date, my lord, in the month of
Yeah,
May.
yes, suggested it.
I'm appealing. Actually, my junior name is reflected. I'm appealing.
Okay. No,
Any-
suggested it.
my lord,
Let it be after 22nd of May, any day.
22nd
Right.
of May.
After 22nd of.
Heard, Mr. Hawk, learned counsel for the applicant, and Mr. Sutter, learned counsel for the respondent.
no, please just.
This application under section 151 of the Code of Civil Procedure is prepared by the applicant for early hearing of RSN number 155 of 2011. The learned counsel for both the parties submits that the matter may be listed on
26.
26/5, my lord.
20,
26/5.
26/5.
These two is due.
They are allowed. Accordingly, this IA is then disposed of, directing the registry to list the RSA number so and so on 26.
Obliged. 36. May it please your lord. Sir, office note dated 6/4/10. LCR was called for lord.
Heard, Mr. S. J. Sharma, learned counsel for the petition. office note dated 6/4/2026 indicates that original TCR has not yet been received, and neither edit card nor answer notice has been received back by the registry in respect of the sole respondent. What to do? You want to take fresh step?
Also, it may be awaited, Lordship, because
Okay. List the matter after 2 weeks, awaiting service report upon the sole respondent. Registry shall also issue reminder to the learned court below for transmitting the record without further delay. List after 2 weeks.
obliged.
May I please the lawsuits? This case notice was issued on 11/3/2026 lawsuits. Returnable was fixed on 10/4. So 10/4 was date fixed for holiday. According, I filed an IA, and on the basis of IA lawsuit disposed of, and today fixed the matter, and the court below, that case is also pending. Notice yet to be served, lawsuits awaited. Short date may be given, or in the end for the ends of justice, that proceeding may be stayed. That case is for argument, and lawsuit stated at this stage interim is declined.
No, the problem is that in your application, if you have failed to explain due diligence
That
in
what
filing the
is-
petition,
that-
therefore no interim order was granted on
If-
that day.
on that count, lawsuit, even Supreme Court says for sole ground of due diligence lawsuit that cannot be.
No, 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 no,
fair.
no, no, no.
On that count lawsuits
No.
at this stage, my submission is that since it's a
No,
very
no,
good
no,
case laws for amendment,
After the amendment, you have to explain it.
that due
And
diligence.
unless
must
there
state
is
that all the
explanation, it cannot be accepted.
Some in paragraph number 3, a short description is given regarding delay lawsuits. With this year and that were delayed.
No, no, no,
the
no.
Court below.
You have failed to explain it before the learned trial court.
Lawsuits.
Heard, Mr.
Trial court
Borneo,
was
learned
one
counsel to
submission.
the petitioner office note dated 28/3/2026 indicates that notice issued to the sole respondent. Notice was issued to the sole respondent by speed post and also by usual process, but the same has not yet been received back by the section. List the matter after a week, awaiting service report upon the respondent.
38.
Date lawsuits, because
After
that case is pending.
After 2 weeks.
Obliged.
6 of May. 6/5.
5.
But if the sole respondent has expired, Lordship. So we have filed a petition for substitution along with setting aside abatement and delay condonation petition. Lordship. IA civil 881 is the delay condonation petition. There is a delay of 1322 days, 1322 days. At this stage, Lordship may issue notice to the legal heirs of the sole respondent.
Heard, Mr.
VS Development.
Learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 1,322 days in filing the petition for setting aside abatement. Let notice be issued to the opposite party. Opposite parties are returnable in 4 weeks, step by speed post and also by usual process within a week from today. List after 4 weeks.
Lordship.
39.
Please, your lordship.
You actually have filed few applications here, one for the stay of the main judgment of the first appellant judgment dated 21st November 2011, Your Lordship. Your Lordship, in the this is the
No,
matter-
whether any execution petition has been filed.
No, Your Lordship.
May I point out?
We have no, we have
May I point out, Lordship, one thing? My learned friend has filed this application for stay of the impugned judgment. Lordship. But that was already stayed by this honorable court, Lordship.
When?
In the year 2012, Lordship. Kindly
there
see-
is no order of stay, Lordship.
Lordship, kindly see miss case number 1555 of 2012. Lordship. 1555 of 2012.
Can I have a copy if you have?
This is state. Okay. Order dated, Lordship, 7/6/2012. Last paragraph.
Yes, it is that.
In fact, Lordship, thereafter another.
Also, the other application, Your Lordship, is the
Another thing, Lordship. Thereafter, Lordship, another application was filed under order 39 rule 1 and 2, Lordship. That was also there. Lordship, there is a status code, Lordship. Kindly peruse the.
even after the stay,
One
if my
double-
learned friends saying that the stay have already done, Your Lordship, even then they are continuously violence in our property, Your Lordship. That is why I filed this application and another application, which is the additional of substantial question of law, Your Lordship. In which, Your Lordship, basically this matter is not between the ownership of the property. It's between the main owner, which is the actual purchaser, and the person who is tenant, which is taking into tenancy by the actual owner who is sale the property to the applicant, Your Lordship.
And Lordship,
This
I
is the
filed
only-
reply of that application, Lordship. Order 41 rule 5. I will be allowed some time. I will file objection.
Your Lordship,
there is
this
a
matter
clear
is
and
pending
status
since
code also.
2011, Your Lordship.
And matter is the hearing stage, Lordship. Lordship had the matter on several occasions. Matter was part heard, Lordship. Now that is come because of this.
I have filed so
application
many criminal complaint, Your Lordship. They are continuously making violence in our property, Your Lordship.
objection, Lordship, against.
Even after
against
stay,
what-
Your Lordship.
One by one.
Please, Your Lordship.
Lordship had the matter, sent the matter for mediation, Lordship, twice.
The
And a mediation failure.
trial court, Your Lordship, has taken all the evidences and on record and the fact of law, and they accept all the facts. And the order of the trial court was in our favor, but the first appellant court, Your Lordship, has ignored all the facts, all the evidences, Your Lordship. They just take one error mistake, which is the sale deed in which one executor's sign was not there. This is the main argument from them, Your Lordship. In my submission, if there is any error mistake, then this is dispute between the executor and the purchaser, Your Lordship. They are accept themselves that they are tenant of the actual owner, Your Lordship. Again, they are claiming that the property belongs to them only.
Then the matter come up for final hearing, Lordship. Matter will be argued by both of us.
This is nothing just for openly gundagardi, Your Lordship. This is continuously violence. We have filed multiple complaints there, Your Lordship. I'll submit all the complaints in front of the Honorable Judge, Your Lordship.
In their application, not a single complaint is annexed, Lordship. In their application.
Your Lordship, MLC is there, all the criminal complaint has there. Few complaints are registered there also, Your Lordship.
They are in the application, Lordship.
All these complaints are pending in criminal court of your lordship.
No, the problem is that on previous occasion you remain absent. 10/3/2026, this matter was listed for hearing. You remain absent.
Your lordship, sorry, I couldn't hear. No, your lordship, on the last date I was there only on 10th of March, your lordship.
10th of March, you were here.
Yes, your lordship. Actually, I've left for a few minutes and then matter was heard and I came and submit before the reader, your lordship. My name is there on the order.
So you see, the matter has impugned judgment and order has already been stayed.
Yes.
So where is the question of staying the matter again?
Your lordship,
Still, it's for the
continuous
fact
violence
that
is
they
there.
have
They are constructing on the property even after stay.
done. That is in these
There is I'm a newly engaged advocate in this matter. There is lots of question of law which is actually not there. So I filed this application for that also, your lordship.
No,
Apart
that question of if any additional substantial question of law is required to be framed, that will be considered only at the time of hearing,
Yes.
not today.
Your lordship, I can file this additional for application for additional substantial question of law at any stage, your lordship. As per
No,
the section.
we have already framed the additional, no, sorry, substantial question of law at the time of admission of the appeal. If at the time of hearing, this court find it necessary, only then, after giving notice to both the parties, the court can.
Your lordship, I'm requesting to put the matter for final hearing.
Yes,
So
yes.
we'll argue.
Final hearing, yes.
That will be better.
Part Miss M. Singh, learned counsel for the
Monica Singh, your lordship.
applicant, and also heard Miss Bhattacharya, learned counsel for the sole respondent.
Not sole respondent, lordship, that is also wrongly.
In this application,
Lordship, that is not brought on record in their application, lordship, that is. That respondent was expert, then legal heirs were substituted, lordship. In the main appeal, lordship. But they have
this
mentioned-
application under Order 41, Rule 5 of the Code of Civil Procedure is prepared by the applicant for staying of the impugned judgment and decree dated 21st of November 2011, passed in title appeal number 16 of 2009, passed by the learned civil judge Dibrugarh, reversing the judgment and decree dated 12/5/2009, passed in the title suit number 111 of 2007 by the learned Munsif number 1 Dibrugarh, and also for restraining the respondent, his agents, associates, or any person claiming through him from interfering with the peaceful position of the appellant over the suit property, or creating any third party interest therein during the pendency of the present appeal. However, Ms. Bhattacharya, learned counsel for the respondent, submits that this court, by order dated 7/6/2012, passed in Miss case number 1/555 of 2012, has already stated the impugned judgment and decree dated 21/11/2011, and she also submits that in which my case it was
1556 of 12.
1556 of 12.
Your lordship may take my submission that about their continuous violence and they are continuously constructing on that property even after stay, your lordship.
1556. Order dated 13/12/2012.
And by order dated 13/12/2012 in Miss case number 1556 of 2012, the parties have been directed to maintain the status quo of the suitland till disposal of the second appeal. second appeal. And as such, this interlocutory application is not at all maintainable. And she prays for listing the RSA number 92 of 2012 for final hearing. However, learned counsel for the applicant has pointed out that the respondent herein have been continuously violating the order of this court. However, she submits that the matter may be listed for final consideration. When?
Your lordship, maybe in the month of June.
In the month of June.
Possible, yes, your lordship.
Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that races list the matter on
Any date
second-
15 to 26. Any date to 15th of June to 26.
Okay, madam, 15th of June. Okay, 15th of June.
15th of June, much
Okay,
obliged. Your Lordship.
okay, objection against her, that petition, that some allegation that he has brought. Otherwise, lordship may dismiss that petition, but that is not mentioned.
I'll file all the complaint before the honorable court. With the proof, your
they have
lordship,
not
with the
filed.
proof of MLC,
however,
videos are there, your lordship.
However,
They
a
are
copy of this
constituted
interlocutory
violating, the
application
state.
is furnished to Ms. Portasaji so as to file his response.
Yes.
Supplementary list, item number 44.
Obliged, your lordship.
Service available. Respondent to 3132. Huh? কি? না, এইটো অহা নাই বুলি লিখা আছে।
So, whether the date is available with you? Date of respondent number 4.
Yes, Lord. In fact, Lordship, there was earlier Lordship on IA 126 to 2016 Lordship. One earlier RSA was also there Lordship. Therein Lordship, the plaintiff filed one application wherein it was stated that Omibora has already expired in the year 2009. In fact, this was an application for substituting the name of her husband. He died in 2016. His wife died in 2009 itself. I'm purchasing a copy of the petition.
Lordship, the legal heirs of respondent number 4 have already been made parties.
3-1 and 3-2 are there. Lord.
However, their service is still awaited, Lordship. Service report is still awaited, Lordship.
No, Mr. Nayak, in the order dated 16/3/2026, it has been recorded that you could not furnish the date of respondent number 4.
Date, Lordship, I am still unable to place, Lordship, but on record, Lordship, it was placed that she died in the year 2009.
No, that's all right. But the specific date is necessary. So as to
Lordship,
enable
my
them to
petition
file
is
an
once the
application.
service in respect of 3-1 and 3-2 is complete, Lordship. They are legal heirs of respondent number 4, Lordship. So they can, I think,
Okay.
that
3-1 and 3-2 are the legal heirs of respondent number 4. 4.
4, yes.
Okay.
So if the service report in respect of respondent number 3-1 and 3-2 is there, Lordship, I think the state should be complete. In fact, registry was directed to place the report first. Registry to
No, as per office note dated 9/2/2026.
Lordship.
Neither ID card nor unserved notice issued to the respondent number 31232 is received by the section.
Lordship, may kindly peruse office note dated 8/4/2026, Lordship.
Yes, same thing. Not completed. Heard Mr. Singh, learned counsel for the appellant, and Mr. Nayak for the respondent number 1.
Yes.
Office note dated 8/4/2026 indicates that neither ID card nor unserved notice has been received in respect of respondent number 31 and 32 till date. The said office note also indicates that neither ID card nor unserved notice issued to the respondent number 2 has been received by the section.
Lordship, may I submit one thing, Lordship? Here the address of respondent number 2 is not clear, Lordship. Lordship, I have a specific address, Lordship, of respondent number 2, including her house number and everything, Lordship. Because I have urgency, Lordship, because this is a suit, Lordship, going on since 2008. Lordship, he may be directly in respect of respondent number 2, Lordship, in this address.
Lordship, we have already taken steps upon the respondent number 2
address is
in
not
new
counted,
address, Lordship, in new address, Lordship, after taking instructions, Lordship.
You see that address?
House number is there. Lordship, let us wait and Lordship.
Okay. Okay. And the said office note also indicates that no substitution application has been received in respect of the deceased respondent number 4 till date. However, Mr. Nayak, learned counsel for the respondent number 1, submits that respondent number 31 and 32 are the legal heirs of respondent number 4. Respondent number 4.
It is clear from that application also, Lordship. That application was filed in 2016. Herein, Lordship, in respect of one Noren Bora, Lordship. And the respondent number 4 is the wife of Noren Bora. And 31 and 32 are the son and daughters of Noren Bora and Famipara.
The said fact is apparent from the application. Interlocutory application civil number 1262 of 2016, filed in RSA number 256 of 2015. Accordingly, it is provided that no substitution petition is required to be filed in respect of this is respondent number 4. Registration lays the matter after 2 weeks, awaiting service report upon respondent number 3132 and respondent number 2.
I'm just praying for a date.
List the matter on
11/5.
11/5.
Lordship, interim order may be continued.
Interim order pass earlier shall continue.
Timing item number 1.
May I please, Your Lordship, my lord. Here in this revision petition, my lord, petitioner has challenged the order dated. In fact, my lord, 10/12/25, 21, 8/24, and 10/12/25 for restoration, my lord. His suit was dismissed for default, my lord, under Order 9, Rule 8. Your Lordship may kindly found first impugn order is page 66, annexure 8, my lord. Both sides filed Hazira, but none turned up. Lordship got it. Peruse the case record. Upon such perusal revealed that the suit is pending stage of GIA since
27/3/23, it is also revealed that the plaintiff side did not comply order dated 11/6/24 and did not furnishing copy amended GA and also by not depositing cost of rupees 1,000. That is already deposited, my lord. This I have that order I have annexed. The plaintiff side did comply the order dated 27/2/23, 14/6/23 and 10/11/6/21 and has simply filed Hazira on 22/7/24 and today also 21/8/22. GA report is not yet returned because plaintiff did not furnish the same to GA. In a suit, it is duty of the plaintiff to take active part and instant suit from the conduct of the plaintiff seems that he is not interested to proceed with the case due to the inactive rule of the plaintiff and other side. That is, defendant should not be suffered, and considering all aspects, I am of the opinion that there is no justification to allow the instant suit to be lingering in the court of any further. Hence, I deem it fit proper to dismiss the instant suit for default as per provision under Order 9, Rule 8. Here, my lord, Rule 8, that if the plaintiff is absent, but in this instant case, my lord, Rule 8 here, my lord, it mentioned where the defendant appears and the plaintiff does not appear when the suit is called for hearing. They have submitted
Here,
their,
the parties remain present.
my lord,
Here, both the parties remain present.
remain present, my lord. In his order, my lord, itself, and I have also annexed the Hazira, my lord. Then how the Order 9, Rule 8, my lord, is applicable, my lord, in this case? If they dismiss, my lord, that's different issue, my lord. But Order 9, Rule 8 for dismissal or default is not applicable in this instant case, my lord. For I have,
But the fact remains that you have failed to comply with earlier orders.
my lord, I have paid the page 55, your lordship may have found it. Page 55 and 56, my lord. 27/2/23, my lord, order, my lord. This type copy and next page is, my lord, in handwritten. GA fees of rupees 1,000 has been received by GA Bappaditto Bhattacharjee fixing 13/3/23. That amount is already paid, my lord. And so far as GA report is concerned, my lord, first GA report is already submitted before the court, which I have already annexed, my lord.
Okay, let
That
notice
is in
go.
the next page, page 57.
Let notice go.
My lord.
Heard, Mr. I. Alam, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 10/12/2025, passed in Miss Case number 172 of 2024, arising out of the order dated 21st of August 2024, passed in title suit number 138 of 2015 by the learned civil judge, Junior Division number 4, Kasar Silsor, whereby the suit of the petitioner was dismissed for default under Order 9, Rule 8 of the CPC. Where is the petition and the documents placed on record? This petition under Section 115 of the Code of Civil Procedure, read with Section 115. Where is the petition and the documents placed on record, and also where is the impugned order dated 10/12/2025, and also the order dated 21/8/2024, passed by the learned civil judge, Junior Division number 4, Kasar Silsor, NPS number 138 of 2015. Let notice be issued to the respondents, returnable in 4 weeks, step by speed post and also by usual process within a week from today. List after 4 weeks.
God bless you.
Time being item number 23.
Well, in this case, my lord, we have taken steps through paper publication, my lord, against respondent number 2. So in that respect, my lord, the service is completed. Let it come for, my lord, under Order 41 Rule 2 column. One, no? One.
Order 41.
It should be yet to be admitted, my lord. Second appeal.
No, today this IA is listed.
Yeah, I is for, my lord, For publication. We have filed an affidavit.
When?
On 25th of March, my lord. I think it's not in record. Huh? Yeah. Affidavit है paper publication.
When did you file it?
25th of March, my lord.
But it is not available on the record.
Oh, it's maybe it's not in record perhaps then.
Part Mr. Chakraborty, learned counsel for the applicant. Mr. Learned counsel for the respondent opposite party. Mr. Chakraborty submits that he has already taken step for publication, for effecting service upon respondent number 2 by substituted mode, that is by paper publication, and he has filed one affidavit enclosing the relevant papers, but the same has not been placed on record. Accordingly, it is provided that recessal lists the matter on next Friday. And in the meantime, recessal take the affidavit filed by the applicant hearing with this record. List on 18.
For admission, item number 11.
Your Lordship, we have withdrawn our wakalatnama as counsels for the petitioner in this matter. There's been a change in counsel.
Part Miss,
M. Das.
learned counsel for the petitioner. What is your submission?
We have withdrawn our wakalatnama in this matter. No, the necessary records and the NOC has been handed over to the petitioner. We are not aware if they've engaged in a new counsel. We just want to inform this honorable court.
Ms. Das submits that she has withdrawn her wakalatnama and handed over the brief to the parties. But she is not aware of as to whether any counsel has been engaged by the petitioner or not. In that view of the matter, it is provided that recessal issue notice to the petitioner within 1 week from today. Recessal list the matter after 4 weeks. After 4 weeks, and recessal also delayed the name of the petitioner, the name of the counsel for the petitioner from the cause list.
Item 12.
Well, this is a matter under the Land Grabbing Act, my lord, where my lord was converted into my lord of civil division petition, my lord. Initially, there was filed writ petition. Now, my lord, of course, the stand that was taken by the department was my lord, that in the process of forming my lord, the appellate tribunal, because the appellate tribunal is not there. Therefore, we filed the writ petition, my lord. And the stand was taken that they're in the process of forming the tribunal. The finance department, my lord, perhaps in position to, my lord, say how far that has gone. That's one aspect of the matter. Otherwise, my lord,
Initially, we filed it under 226, then it was converted into 227 petition by this honorable court. We are basically challenging the judgment of 26/4/2022. The finance department does it, if it's got the instruction, we don't know that.
For the revenue department, respondent number 1. So under the scheme of the land grabbing act, Prohibition of Land Grabbing Act 2010, has to be constituted one appellate tribunal, like the special court, but that was not constituted. On papers, secretary was done by the department, and under the scheme of that act, that appellate tribunal has to be keeping there in one chairman, who has to be retired as a high court. Accordingly, several retired honorable judges of this honorable court were approved by the parliament for constituting a special court, but almost all of them have refused. So under that circumstances, now there is a move, perhaps to amend the act itself, but that is under process. That is under process. And since under the scheme of the act, there is a appellate tribunal. Now, because of the fact that the appellate tribunal has not been constituted, so naturally, from the orders passed by the special tribunal, that is the first court under the Land Grabbing Act, the higher proceedings before this honorable court would lie in the nature of the civil division. Here on facts, it is between the petitioner and the respondent. So far as constituting the appellate court, or for the matter of revisiting the provisions of the 2010 Act, in that I see a little more accommodation from the because I have to get the updated discussions.
But till then, can we keep this matter pending?
Otherwise, this was keeping in view the se between the parties. Because it is now, if now this verification is converted into a civil division application, the parties may not be left remediless. They can pursue their remedy before this honorable court in the civil division process. Because that aspect is another, because that will be a legislative exercise done by the final government. Now, keeping that apart for the timing, it's very well dispose of the adjudicate this matter on merits. That is the difficulty. In fact, they have done a strenuous exercise, for last more than 3 years, nothing has fructified. So now there is a move, between the 2 or 3 departments, including the judicial department. Some views have also been taken, from various departments, whether to revisit the provisions of the act. That is one aspect of the matter. And then there is another aspect of the matter which may also conflict in law, what we normally say, in the appellate tribunal, there has to be one officer of the rank of a retired district judge. Now, the first tribunal, the trial tribunal, special tribunal under the act, that is also manned by an officer in the rank of a district judge. Now, that conflict may arise, If an order is passed by an officer, only the jurisdiction of a district judge.
No, that is. You say the appellate tribunal is yet to be constituted. So that is now a hypothetical question. So whether the parties are ready to argue the matter?
I can argue what happens when 227, your lordship knows, the moment it is converted to 227, limited grounds. That's where I stand prejudiced. Otherwise, because the provision is there isn't a provision for appeal. Now it's the state government which has not been able to form the appellate tribunal, which is creating all the problem, my lord. I understand that, my lord. But this matter has been pending for quite some time. That is also another aspect of the matter. So, my lord, this is the problem is, my lord, once it is converted to 27, my lord, please become very limited. That's, my lord, where I, my lord, because otherwise, my lord, this is, my lord, has got a lots serious consequences, serious civil consequences, my lord. And, my lord, if a criminal consequences are also there, my lord, because I can be punished, I can be sent to jail, my lord. And without there being an appellate provision, my lord, 227 very much limits my, my lord, my lord, my right, my lord, my lord, the spectrum or, my lord, the area of challenge, my lord. So that's where, my lord, the problem lies. Otherwise, my lord, the matter, my lord, can be argued, my lord. Or, my lord, can I pray for one thing, my lord? Lordship will admit this petition is fixed for hearing, my lord.
No. Because they are not allowed us to occupy my land. And I cannot cultivate the land because of my execution case is also pending. It is a state. Therefore, I want the this proposal.
No, that's all right. Unless we admit this petition, can we go to hearing?
Why not? It will take some time because it is admission recorded stuff. We have appeared, the side also ready. It can be hard. It is a very small matter. Hard to dispose of.
At the admission stage itself.
So many cases are disposed of at the admission stages. It can also be disposed of. If my learned friend is not ready today, then it may be taken up after.
Otherwise, my lord, I can argue this matter, my lord. That is not a problem, my lord. Only thing is that, my lord, since the my lord,
He knows. He filed a 226 petition. But 226 scope is very limited. And so far, this case is concerned. And 227 only, it is a civil liability. A civil liability, the tribunal has, that they are trying to dispossess me. They are the land grabber.
well, in any case, my lord, then, my lord, of course, it's only 1 o'clock, my lord. Perhaps it has to be taken up in the second half, my lord. But can it be taken, my lord, if, I don't know how much lordship, my lord, if it can be, my lord, taken up a little later, my lord, in the second half, or, my lord, if his lordship's list is almost over, then, my lord, of course, lordship will take 2, my lord. Otherwise, my lord, can it be, I pray for some, my lord, some short, my lord, accommodation so far as time is concerned, my lord, if it can be so done, my lord. Because at 2, my lord, some other matter is fixed, my lord. So that's the reason. Otherwise, my lord, if it is can be, my lord, done so done, my lord. Otherwise, my lord, I'll start the argument, my lord.
So let it be on Thursday, hearing day.
Thursday, my lord.
23rd.
23rd, my lord. Yes, can be done, my lord.
Okay.
I'll do the matter, my lord.
As agreed by learned advocates of both the parties, recessal is the matter on 23rd. On that day, an effort will be made to finally hear and dispose of this petition.
Oblige, lordship.
Item number 14.
And endeavor.
May I please your lordship?
Yes.
The petitioner in this instant petition prays for setting aside the impugned order dated 30/11/2024, passed by the learned member MA City Lakhimpur in miss case number 9 of 2023.
Order dated 38/11/2024.
2024. The impugned order is on page number 14.
Lordship, my humble apologies for interrupting. Lordship, I'm appearing on behalf of respondent numbers 1 and 2. Lordship, we do not have a copy of this case. Lordship, that is why we are at a disadvantage today. And this matter be taken up on another day, if possible. Lordship.
You are for respondent number?
Respondent number 3,
Respondent number 3.
as based on entrance.
So the accident took place prior to the amendment act.
Yes, your lordship.
During the period of corona.
Then how can this act can be applied? Amended act. You have no objection.
There is a judgment of coordinate bench also of this honorable High Court.
You have not received any copy.
Regarding this, regarding this case. On behalf of respondent number 1 and 2.
So let it be on Thursday. You furnish a copy to him.
Lordship.
Heard, miss, your name, please?
M. Acharya.
Learned counsel for the petitioner. Mr. Goswami for the respondent number 3. Mr. M. Bhoya, learned counsel for the respondent number 1 and 2. Mr. Bhoya submits that he has not been furnished with a copy of this petition. Accordingly, it is provided that learned counsel for the petitioner shall furnish a copy of the petition to Mr. Bhoya during the course of the day. This is a list of matter on Thursday.
Item 15.
Everyone. Yeah.
May I please, Your Lordship?
Mhm.
Lordship, my senior is not able to come today. His daughter is a leader. He is a attend the medical.
Pardon?
Mr. Tuesday.
Ziuddin. Tiuddin.
That's a good one.
So when can it be fixed?
Next week.
Next week. Heard, Mr. A.C. Sharma, learned senior counsel, assisted by Mr. Bhartas, learned counsel for the petitioner, and Mr. Your name, please?
Tuesday.
Learned counsel appearing on behalf of?
Respondent number 1 and 2.
No, you are appearing on behalf of?
Respondent number 1 and 2.
Oh, I appear, sir.
Oh,
To senior.
yes, Ahmed, sorry.
S. Ahmed, learned conducting counsel for the respondent number 1 and 2. Respondent number 1 and 2. Mr. Uddin submits that the conducting counsel, Mr. Ahmed, is not present in the court and he plays for listing the matter in the next week. They are allowed to list the matter on
29.
29th. Okay.
Interim order. Interim order will continue.
Interim order pass earlier shall continue.
Supplementary list, item number 42.
Let's please, Your Lordship.
Yes.
Before going into the impugned order, Lordship, I would like to just draw a kind attention, Lordship, to the plaint. This is originally they have filed the suit. They are the landlords. Respondents here are the landlords. They have filed a suit for eviction of the tenants. I am the tenant, Lordship. In the plaint itself, Lordship, the rent was mentioned as 7,555. No dispute on that part, Lordship. At page 12 of my petition of the CRP, I have annexed the plaint, Lordship. At page 12, if Lordship goes, the relief part. In the prayer, Lordship, B, the decree be passed declaring that the defendant is a defaulter as monthly tenant and the plaintiff is liable for eviction. Then prayer D at next page, Lordship.
the decree be passed for realization of the interim and future rent and from the month of April 2018 till eviction of the defendant, lordship. So their claim is for eviction on the ground of defaulter bona fide requirement and realization of the area rents. According to their pleadings, that I have not depositing the rent after the completion of the term of tenancy. We have
After the
denied
completion of,
term of completion of the tenancy part, which was according to the agreement, it was up to the March 2018.
so it has already expired.
Already expired. That part there is no reason. They have filed the suit for eviction and we are challenged that part, lordship, regarding their grounds. That they have no ground.
Where is the impugned order?
I am coming, lordship. Impugned order is at lordship, page 27, lordship. It is in very limited campus, lordship.
Yes.
Yes, before coming to the impugned order, lordship, just I would like to draw the attention of page 25, lordship. On the completion of my DWH, DW3 was discharged after cross-examination and summons were issued to the official witness. Here the official witness was called to prove the non-judicial cases, lordship, by which I am depositing the rent in the court. Coming to the next page, lordship, while the summons were pending, official witnesses, on one day he turned up, on one day he did not turn up. On 21/11/2025, lordship, plaintiff may read the order, lordship. Plaintiff as well as the defendant represented, the case is fixed for evidence of the official witness. JAO Jayanta Thakuria is present on receipt of summons, but he has not produced the requisite case records, stating that he has not been able to trace out all the case records enlisted in the summons. After the matter was taken up for hearing, learned counsel for defendant has filed a petition under 2931/25, prayed for another opportunity to summon the said witness to produce the aforesaid documents. The learned counsel for the plaintiff, on the other hand, have filed a petition number 2932/25 at around 1 p.m. citing a judgment of Honorable Gauhati High Court in the said petition, praying that the petition may be rejected. None appeared to make submissions on this petition at later half of the day, fixing the hearing on 28/11/2025. On 28, learned trial court has considered both the petitions, our petitions, and their objections, and passed the impugned order, lordship. Just I am straightway taking your lordship. Having para 8, page 28, having said that it has been seen on perusal of the summons issued to the concerned official, that is the JAO of the Office of the Civil Judge Junior Division, that near about 65 NJ cases records pertaining to the deposit of the rent have been requisitioned by way of summons, which have been signed by the concerned official himself. However, a major portion of the said case records are nowhere mentioned in the list of the documents submitted by the defendant, and no leave of the court has been obtained as to exhibit of the same. Concerned JAO Jayanta Thakuria is cautioned to this regard. At the time of hearing, learned counsel for the plaintiff has submitted they have not disputed the factum of deposit of the rent in court. He has also submitted that this is a mere suit for eviction on the ground of bona fide requirement, and therefore proof of payment of rent may be dispensed with. This finding is not based on record, lordship. This is not a suit merely on the bona fide requirement, lordship. However, on perusing the prayers enumerated the plaint, I find that this is a suit for eviction of the defendant on bona fide requirement of the plaintiff as always ground of default of payment of rent. Nevertheless, no prejudice will be caused to either party in this case record if the case records of NJ cases accumulated over the past decade relating to the deposit of the rent are not exhibited one by one along with the evidence of the defendants. Rather, if needs arise, same can be called for and taken judicial notice of at the time of argument. Petition number is rejected. Here, abruptly my petition got rejected, lordship. Though I have no necessity to file a petition because witness is present, he could not produce. He has to bring the records. Suddenly my evidence was closed, case was gone for argument, lordship. So if I fail to prove the NJ cases, lordship, that I am depositing since April, first deposit was in May, court will pass a decree against me for the arrears of rent.
No. If as per report of the JAO all the records are not available, then
No, he has not made any, he simply said, I could not trace out the records.
yes,
He is not saying that records are not available, not on that line, Lordship. He could not trace out the records. So another date should have been given. And that JO is the under administrative control of that particular court, Lordship. It is the Court of Civil Judge, Junior Division number 1, Lordship. Records are maintained by them. In their plaint, they are clearly stating that we are not depositing the rent. Their case is of eviction on the ground of defaulter, on the ground of, and another prayer is arrears of rent, recovery of arrears of rent, Lordship. If I fail to prove, there will be a decree against me at the rate of 7,000, almost 1 lakh rupees per year, 8 to 10 lakhs, without my fault. I am depositing the rent regularly, Lordship.
no.
And I am simply proving
no,
that
you
a
say,
registered will be there, Lordship.
in paragraph number 9,
Right.
this first line, at the time of hearing, learned counsel for the plaintiff has submitted that they have not disputed the factum of deposit of rent in the court.
They have admitted mainly on one record, Lordship. May I draw your attention, Lordship? On para 7, Lordship.
Hmm.
Offered rent to the plaintiff, para 7, last line, Lordship.
Hmm.
Only on 4, 5, only one admission is there, Lordship.
Hmm.
They are clearly saying during cross also that I am not depositing the rent. That is their decree. Let them make a submission here, Lordship, that yes, they have no dispute on my rent.
The
Rent has
question
been
is
deposited.
whether
They have withdrawn.
no, the question is whether the suit was filed on the bona fide ground also, bona fide requirement also.
Yes, Lordship. They have claimed both grounds, bona fide grounds as well as the defaulter grounds. Sir.
Then what wrong with this observation?
No, court has comes that no prejudice will be caused.
Hmm.
Lordship, if I fail to prove, Lordship, I would like to rely upon a judgment, Lordship. If I fail to prove that yes, I am depositing the rent, because after the judgment of Abdul Mateen Chaudhary, Lordship, it is the paramount duty of the tenant to deposit not only prior to filing of the suit, but during pendency. I would like to draw the attention of para 13, Lordship, of the judgment. (2016) 3 GLT 279. From the middle part, Lordship. Lordship would like to take a break for the lunch.
Yes, Mr. Dhar, what is Mr. Biswas, what is your stand?
My stand, your lordship, first of all, if your lordship takes my affidavit, which I have filed here. Here, what they have done in their evidence by DW1, they have exhibited the entire document, the NJ records. It was already exhibited and cross-examination was also done on that. Now, after that, these records are now being called because they have 4 witnesses. 3 witnesses, they came, deposed, and in DW1, they had exhibited the entire records of NJ records. And the trial court, before the trial court, the plaintiff advocate had cross-examined them. So if the original is required, that is the observation of the trial court, that the original is required, because it has been cross-examined. It is not that they were not given the opportunity to examine. They have already, if your lordship sees page 94 of my, if you the evidence in page 89 of my evidence, the affidavit, I have given the evidence on affidavit of DW1, who is the petitioner before your lordship. If your lordship has got 89, your lordship. And in page 94 of the same, your lordship will find from exhibit E1 till exhibit E36 are the NJ records from April 2018 till March 22. So this was already exhibited. The certified copies were already exhibited and they were cross-examined. So from that day, the official witness, who is the Siyastadar of Munsif Court, could not come. From 8 adjournments they took to first issue summon to bring. But the case remains, as the trial court has rightly held, as it has been already exhibited. If the court requests to verify the photocopies, the certified copies with the original, that can easily be called for and looked, because it is not a case that they were not given the opportunity to adduce evidence with regard to the deposit of rent. It is there on record. It is there. They have exhibited it. But the plaintiff side has also examined them on that, Your Lordship. Page 96 is the cross-examination. Apart from 2 exhibits where 3 months at a time it was deposited. In one case, 3 months at a time was deposited, and another case, 2 months rent was deposited. Others have been cross-examined, nothing was cross-examined with regard to that. Now, the trial court has rightly held that if at all the original would be required, because the certified copies are already exhibited. If the originals of those are required, the court during the course of the judgment or during the course of the hearing can easily verify your knowledge. Because it is not a case that they were not given an opportunity to establish that they have deposited the rent. Because it is, they have already exhibited. And cross-examination has already been done by the plaintiff side, Your Lordship. So there is no hardship would be caused to him to establish, because from April 2018, the suit I think was filed in 2018, from the very first day of the suit year till 22, the entire records of the NJ records have been exhibited by the plaintiff, defendant number 1, the main the tenant. So the trial court has said that as it is already on record, so if the trial court feels the necessity to cross-examine, to verify whether the certified, because there was no question raised by the plaintiff itself during the cross-examination about the genuinity of the certified copy. So it is on record, Your Lordship. So if at all it is there, it will be decided on those certified copies, because the court said that the court feels necessary, it can call for it, because there was no requirement for any, because the official witness will only bring on the original, which is already exhibited, and already 8 dates have been they have taken 8 adjournments after the DW3 was over for bringing on record this NJ records through the official witness. 8 adjournments after 22/7/24. They have taken 8 adjournments. But my submission would be, Your Lordship, as the DW1 had already exhibited those, my learned senior colleague is stating, those documents, NJ records, have already been exhibited. The certified copies they have already placed on record, and the plaintiff side had already examined the witness. So he is not being prejudiced if the originals are not brought on record now, because the originals are only required when there is a dispute with regard. If Your Lordship sees the cross-examination in the page done, well, I do not suppose where the cross-examination was done, but page 96, the plaintiff side did not raise any objection to any of the certified copies exhibited with all the total exhibits. So there is no dispute with regard to the genuinity, nothing of that. The fact, the learned trial court in para 9, as Your Lordship has stated, the factum of the deposit is not disputed. So
no, para 9 is the submission.
My submission is that trial court's observation is absolutely correct, and there will be no prejudice caused to the defendant side, because they have already exhibited the certified copies of all those NJ records. We have now, those originals, they are now seeking to bring on record now through the official witness. because DW1, who is the tenant, has already exhibited the entire.
Okay,
NJ.
okay. So how prejudice will be caused
Just
to
a
you? So
Because
those NJ cases have already been exhibited.
just one line of that judgment, Lordship.
Mm.
I have referred here, Lordship. Hearing the case when the defendant number one took a plea that he was depositing rent in court for the month of June 2006, and since thereafter he was also depositing rent since July, it was the duty of the defendant number one
Mm.
to call for those NJ cases to prove
Mm.
the rent was so deposited with a fortnight of its falling due along with the process fee. If in absence of the NJ cases, it cannot be ascertained as to whether the process was deposited
No, no,
along with
no,
the
no.
rent.
You
So
see,
to prove a valid deposit, it
here-
is the duty of the tenant to call the NJ cases.
No,
Lordship. Secondly, Lordship, my second submission is, Lordship, if your Lordship come to the last paragraph 11, nevertheless, no prejudice will be caused. This is the word here, Lordship.
no,
If the
no, that's all right. How prejudice will be caused to you?
Coming, Lordship. If the NJ cases accumulated over the past decades relating to the deposit and not exhibited one by one along with the evidence of the rather, if needs arises, same can be called and taken judicial notice of at the time of argument, Lordship.
No, the certified copies have already been executed.
Till the date of my evidence, Lordship. Because after 22, I have also deposited, Lordship. Because it is my duty to deposit till the date of judgment. Otherwise,
No,
court will
whether
pass
they
a
have
decree.
disputed it, is it their case that you have not deposited the
Yes, that is their
rent
case,
in the?
That is their case, Lordship. In the plaint, they have claimed, I am not depositing except one.
If that will go because.
Let him make a submission that during before
I am
trial
saying
court,
that it will
before
be the
trial
trial
court, they will not object me on the so far arrears of rent. I have no objection.
Here are
Lordship.
the only two objections have been raised. Your Lordship will see that they have deposited 3 months rent at a time. That will be the only objection we will raise.
So far, raising
Because it is
this,
there on record. I cannot dispute.
taking
that
8
certified
adjournments,
copies are
this
there,
is not for me,
cross-examination has
Lordship.
been done. The trial, before the trial court, the plaintiff side did not raise any objection. And the only objection they have raised for two occasions. One is when 3 months rent was deposited and another when 2 months rent at a time was deposited. Only 2 points have been
So
raised.
with an observation, maybe this, I have nothing to
Nothing
cause
more, Your
delay,
Lordship.
Lordship,
There
nothing
is
cause
nothing
delay.
there.
And so far the objection that 8 adjournments is not for me, Lordship, it is the official witness has to come.
Official witness.
I can issue summons only. On that day, he is present. The records are maintained by him, maintained by same court, Lordship.
No, no, Mr.
So,
Pudar, you
unless
say,
I am fearing of a
no,
my
no, no, no,
prejudice,
you
Lordship.
see, the last part of the order in paragraph number 11,
Lordship.
rather, if need arises, the same can be called for and taken judicial notice of at the time of argument.
But that is not in the CPC. That provision is not in the CPC, Lordship. Once argument starts, matter goes for judgments when.
No,
That
no,
is
no,
my
no,
fear,
no,
Lordship,
no,
here.
no, no, no. Court can call for it.
If arises, this is the couches with the if arises.
Yes,
Because-
if the court feel it
Yes.
necessary, then it will call for.
Because, and secondly, what my friend is that I have exhibited up to 22, no problem. After 22, even he can come with the register, Lordship. That particular records may not be necessary, Lordship. The register, yes, after 22 till the date we have deposited, and that much to avoid a decree of arrears of rent. Whether my deposit is legal, not in the as per 5(4), I am not on that point. The court is always on that line, Lordship. But arrears of decree, I am fearing of that arrears of decree, Lordship, because it is a rent of 7,555 per month. Even if for 3 years, I will suffer a decree of 3 lakhs or more. Even if deposited. That's, Lordship, within caution may be given, Lordship, order that yes, a register, because NJ cases registers are there.
Well, I'm saying. Your
Staff may
Lordship,
come and say, okay, they have deposited up to this last day. If
the
I have not
need
deposited,
arises,
that will help them. If I have not deposited, that will help them for eviction.
If that is the, because the thing is, when I filed that case, that was the issue. Now, during the course of the trial, as I don't know why there was no objection taken, there were some additional documents exhibited, which I'm not going into. But the thing remains that they are saying that NJ records are to be original, are to be called. Certified copies have already been exhibited, Your Lordship. And if the needs arises, as the learned trial court has rightly held, if the need arises, the court may look into it to verify whether those documents, because once the plaintiff side has not raised any objection with regard to the certified copies. during the cross-examination, I feel that cannot be a U-turn by the plaintiff side again,
No,
questioning
at
the,
the time of hearing of the argument,
yes.
you can produce those documents.
Yes, they can already put, because certified copies are already there.
Because unless
No,
evidence
no,
brought on
after
record,
his cross-examination.
The examination is already over,
No,
everything.
that's all right. Thereafter, he has deposited the rent in the court.
Yes.
His apprehension is that a court may pass a decree.
for arrears of rental, my
Arrears
position is
of
on that
He is
part.
already.
I am not on the
Lordship,
eviction decree,
First of
Lordship.
all, he is a tenant under sufferance. The tenancy is no longer he is a tenant under sufferance, first of all. His right as a regular tenant has already expired, which is an admitted fact. Now, a tenant under sufferance is delaying the proceeding on a technical issue. I am saying that till
This is-
22 he has deposited. I admit to that it is there on record, except from two things. So the issue would be decided on the documents already exhibited. Now, a person who is already not.
No, Mr. Biswas, you see, his apprehension is that after his cross-examination also, he has deposited rent in the court. So his submission is that the official witness may be directed to produce the register before the court to exhibit that he has deposited the rent or after the after his cross-examination also.
So our apprehension would be, I have no issue with regard to not allowing that, what your lordship feel. But our apprehension that this person who is the custodian and siesta that had taken 8 times adjournment.
For that, I cannot be blamed, Lordship.
I'm not blaming him. What I'm saying is let the argument start. It would be over and the record may be taken note of by the court, your lordship. Because it is there. Let the argument be here. Because merely saying.
Okay, Mr. Biswas,
Your
let us
lordship will
do one
kindly
thing.
consider that.
We will record his submission.
Yes.
That he is apprehending that a decree may be passed
On
in
the
the
basis
event of failing to produce those NJ cases after his cross-examination is over.
But that was, first of all, there is no petition filed before the trial court seeking leave to bring on record. First of all.
Then okay, we will grant him liberty to file an
liberty.
application before the court.
Lordship.
And in the event of filing such an application, court shall dispose of the same in accordance with law.
Lordship.
But at least your lordship, because from.
A date may be fixed, even the trial court may be directed to complete this process within 15 days, 10 days, 20 days. I have no objection at all.
No. That kind of direction cannot be issued. Already one decision of Supreme Court is there.
My only submission would be, your lordship, from 2018, the main petitioner who had filed, he expired during that proceeding. Now his legal heirs are on record. So this should not be prolonged further with regard to a tenant
No,
who is a.
okay. We'll direct the trial court
Yes.
to dispose of the same as soon as
Yes,
practicable.
Lordship.
We
That
will
can
not
be
fix any timeline.
Yes, Lordship.
Without timeline, but at least your lordship, sorry, your lordship is, the thing is only the register as a, without tracing out the records. If the register is allowed, that would be much faster instead of
Oh,
searching
okay.
for the record.
Okay.
Lordship, that can be done, Lordship.
If the register.
Caveat would be heard. Caveat stands of the search. Heard Miss Murtaza, learned counsel for the appellant, and Mr. Mukherjee for the respondent. Ms. Murtaza submits that conducting counsel Ms. R. Sothori would not remain present in the court today on account of some difficulties, and she prays for listening the matter after
1 week, your lordship.
After 1
Need
week.
it.
we are allowed to recess the matter after 1 week.
Obliged.
Number 43.
Yeah, please.
Arrester against the judgment and decree passed in title appeal number 9 of 2012. judgment indicated 24. These are concurrent finding. Okay, what happened? The substantial question of law has already at page 9 of my memo page. Actually, they elaborately given questions, substantial question of law. That's all. The earlier occasions, a statement was wrongly typographical mistake. And thereafter, the Honorable Court directed to submit a corrected copy of memo of appeal, accordingly filed. Actually, the present appellant is the defendant of the original suit, and suit was filed by the present respondent number 1 to 3 against the present appellant and respondent number 10 to 13. And then suit was decreed in favor of the respondent, and then the present appellant along with the respondent number 10 to 15 preferred an appeal before the Honorable DC Judge. And then after hearing both the parties, the learned first appellate court also appealed the judgment of the trial court by dismissing appeal, hence this present appeal. My lord, the impugned trial court judgment at page 16 and appellate court judgment at page 29. Here is the main case is there. The substantial question is law, in that there is joint property. The vendor of the present respondent number 1 to 3 has no right to transfer the fruit property without formal partition.
Mr. Bora,
My lord.
you see, you have suggested as many as 7 substantial question of law.
Yes.
Right?
Yes.
Out of this 7 substantial question of law, which one, according to you, is the substantial question of law? Because you see, this
yes, I am something, Your Lordship. Actually, non-gender of necessary party, subset 2. 2 is also important because there is a 2 original co-partner.
No. You say, firstly, you have to understand what is substantial question of law.
Yes.
So,
there's
a non-gender of necessary parties.
Yes.
So, whether such a plea was not taken in the written statement?
Taken.
Issue was framed?
No.
No issue was framed.
Not framed.
Where the
And then ground number 3. Ground number 3 also, the section 44 of Transfer of Property Act. The property followed by the performer respondent number 8 to the present respondent number 1 to 3, origin plaintiff. That he has no right without being partition of the joint property. Section 44, I'm reading it. And without partition of the joint property, the one co-owner cannot be sold out until and unless partition has been effected. This is a question of law, but learned trial, both the court below has not considered that point.
Let us see the issues.
Yes.
Page number?
In trial court, issue at page 18. Start from 18. of my plea. There has been 7 issues framed by the learned trial court. First one is whether the Jugendranath Sharma has any right to sell the suit property. And 2, whether the plaintiff are in possession of other suit land. 3, whether the Paresh Nath Sharma or his legal heirs, performer defendant number 6, 7 already sold out the share on the patta. 4, whether the sale deed executed in favor of the plaintiff are illegal and void. 5, whether the plaintiff have right title interest over the suit land. 6, whether the plaintiff are entitled to get a decree as paid for, whether other relief parties are entitled. These are the issues. Another very vital point has court decided, the recovery of possession. Recovery of possession has not asserted, paid for, but court has given. Recovery of
Whether
possession.
there was a pair in the plaint,
Alternative pair is there,
then
but they have, first pair has given confirmation possession in the plaint. That means if confirmation of possession has paid for, they must be possessed. But there is no amendment of the plaint during pendency of the suit.
no alternative pair is there.
Maybe, my lord. But they have claimed adverse confirmation possession. And evidence of lead like this. But there is no any averment, no statement that during pendency of the suit, the defendant has dispossessed forcefully or illegally. But plaint has also not amended. But learned court below has given the pair.
No, that a consequential relief can be granted if it is there in the plaint.
May I kindly plaint at page 68.
68.
And it's a C. Got it? In the course title at page 70. 70 and last
No,
part.
come to the pair person.
Yes. Alternative pair is there. Pair number 5. It is further at page 75. It is further alternatively prayed that if during pendency of the suit, the plaintiff are dispossessed from the part of the suit land or from the whole of the suit land, delivery of possession of the suit land given to the plaintiff. But there is no any averment, no any statement has made or plaintiff has amendment during the pendency of the suit. The plaintiff were dispossessed by the defendants. How the learned court below has taken into consideration that recovery of possession. There is no, I have taken the plea also. This one of the 3 points has been taken. Ground number 2. Number non-gender, this honorable court may or may not be. This is a vital point. Regarding issue number 4 and 5 have not considered, properly not appreciated, because can you consider issue number 4 and 5?
Where is the decision of the trial court?
Trial court.
Page number?
Trial court has been start from 16. And issue number 4 and 5 start from page number 21, last portion. Paragraph number 10 of the impugned judgment of trial court. Page number 21.
No, trial court judgment at page number?
Start from 16.
16.
And issue number 4 and 5 togetherly decided. So paragraph number 10 at page 21.
Yes, 4 and 5 are discussed.
But very interesting, in middle portion, they decided at page 22. Page 22. Got it? I'm reading slowly. Prior to this sale, they have entered an agreement for sale with the performer defendant number 8. Performer defendant number 8 means the vendor of the plaintiff. Vendor of plaintiff. A defendant did not challenge the admissibility of the document proved by the plaintiff side. The exhibit 1 certified copy of the sale deed. The only decision taken by the learned court, both the court below, the defendant has not challenged the exhibit 1. Only that consideration enter should have decided. Only this point. The defendant, present appellant, has not challenged the exhibit 1, the sale deed executed by the performer defendant number 8 in favor of the plaintiff. Has not challenged. Only crux of the decision of this.
Yes, exhibit 1 is the sale deed.
Sale deed.
So on the basis of this sale deed, the plaintiff has claimed right title and interest over the suit land.
Yes, but they have not possession. I'm coming to the point. The plaintiff has miserably failed to take possession, and it is established. The plaintiff were not in possession, still not in possession. Only the trial court, both the court below, has taken into consideration both the issues. Only that the present appellant as well as defendants have not challenged the exhibit 1. That it
yes
unchallenged. That's why suit of the plaintiff has decreed by without considering the other law point. That's why present appellant has preferred this second appeal. Because next part, I'm saying, by all the documents which remain unchallenged shows that above purchase plaintiff have acquired right title interest over the suit land, measuring 2/10 lesser, while the defendant number 1 have already hold that performer defendant number 8 has the right to sell the land, and as such any further transfer of in favor of the plaintiff by the said performer defendant number 8 coupled with delivery of possession cannot be held illegal. Now, the possession, regarding possession, the trial court has decided only this point. On that basis, suit was decreed. And appeal was also dismissed of the present appellant. Regarding possession.
No, you say this finding.
Yes, my lord.
This last part of this page.
Yes.
From the cross-examination. Page 22.
Yes, ma'am.
Last line.
Yes.
From the cross-examination of PW 1 and 2.
Yes.
It appears that the plaintiff's evidence regarding purchase and taking delivery of possession over the suit land and remaining in possession for some time is proved.
Yes. No. Then other part I am going to that part. Regarding issue number 6.
Plaintiffs are out of position.
Yes, the issue is the issue related to entitled the plaintiff for the decree as paid for in view of the decision in issue number 1 to 5. Plaintiff is entitled for a decree of declaration of right title interest over the suit land. However, as the plaintiff are out of possession, the payment pair of confirmation possession is rejected. The trial court has established, yes, possession is not there, but the confirmation possession is rejected, but not paid. Not paid. First priority has given confirmation possession in the pair portion. Second option, alternative possession, if
No, you see this paragraph number 10 and 11.
Yes.
They are to be read conjointly.
Conjointly.
In paragraph number 10, it is stated that delivery, purchase and taking delivery of possession over the suit land and remaining in possession for some time is proved.
Yes.
For some time they were in possession. Subsequently, they perhaps they may be dispossessed.
No, kindly page number 21. Kindly consider a middle part. Kindly last part. Issue number 3 above last line. Issue number 3. From the admission of the plaintiff side, it is clear that the plaintiff are in not possession over the suit land. Very clear. Trial court held. Last sentence.
No. Which line you are reading?
Paragraph number 9, issue number 3, above, last line, middle portion, page number 21. From the admission of the plaintiff side, full stop. It is clear that the plaintiff are not in possession of the suit land. Very clear. Paragraph number 9, issue number 3, above. Only one sentence, two sentences. At page 21 of
yes, issue number 9.
Yes.
No, paragraph number 9,
Nine.
number 3.
Above line. Just above.
It is clear that the plaintiffs are not in possession of the suit land.
Yes. From the admission of the plaintiff side, very clear. It is clear that the plaintiff are not in possession of the suit land. If so that, how both the court below has granted recovery of possession? How this learned court below has rejected the pair?
Okay, let us see the evidence of the plaintiff.
No, my lord, I have not annexed the evidences.
Then
there's a I have to and a procedure may be given. Actually, both the court below other points also. My substantive question of law, other part also there. Ground number 2, section 44. Non-joint
section 44 of the transfer of property.
Transfer of property. Ground number 5, regarding possession.
No, this section has not prohibited transfer by co-owners.
Owner. Here in the not co-owner, co-sharer. Here in the co-sharer.
No, is there any difference co-owner and co-sharer?
Co-owner jointly possess a particular patta. Jointly possess a particular patta. but may not be co-share,
Mm.
co-owner.
Mm.
Suppose a dog, two, three jointly possess
Mm.
few people, they co-owner, but may not be co-share.
Mm.
The share may be not be there on a particular portion. But here in this case, originally there are two owners. I'm coming to the points in shortly. Siddhinath Sharma and Prasnath Sharma both were the owner.
Mm.
They have total 10 bigha 3 kathas land.
Mm.
3 kathas land. And Siddhinath share got 10 bigha, 5 bigha,
Mm.
1.5 katha.
Mm.
And Prasnath also fair. The vendor of the son of the Siddhinath Sharma
Mm.
has sold out the land to the present respondent plaintiff. And Prasnath, son of the Prasnath, told the present appellant.
Mm.
This is the crux of the dispute. Actually, Siddhinath Sharma's son is dependent by a performer dependent by 8 Jugendranath Sharma. Jugendranath Sharma sold out his suit land to the plaintiff present respondent, main respondent. And the vendor of the present appellant, defendant, the son of the Prasnath Sharma, he is performer dependent respondent number 6 and 7.
Mm.
The dispute is this. They say, no, my vendor have no right to sell. But after purchasing the land by 5 sale deeds, we took possession. Now still I am possessing.
Maybe.
But
Maybe.
point is, the 3 points is substantial question. The non-joinder of necessary party, the Prasnath, Siddhinath Sharma has eight sons.
Mr. Bora, you say
My
non-gender of necessary parties is always not fatal,
yes.
right? Who is a necessary party? That has to be ascertained first.
Yes.
And this non-gender of necessary parties may be a legal question, but it should not be a question of law, but it may not be a substantial question of law.
Manoj, here this case, substantial question was because the Siddhinath Sharma has 8 sons, but one son cannot sold.
No, this section 44
yes.
of the Transfer of Property Act,
Yes.
it does not prohibit.
Not prohibited.
Then?
But it required to be considered because the property has not been properly partitioned and demarcated. This
Maybe.
share and this share.
Maybe. But he can, as per this section, he can.
My 3 point is there. One is section 44.
Mm.
One is non-gender of necessary party.
Mm.
Next point is the
Possession.
Possession.
But
without pleading.
Evidence is not placed on record.
Yes. But trial board the court has.
How? The court has observed that for some time they are in possession. Plaintiffs are in possession.
But in the other part has clearly plaintiff has admitted they are not in possession. The trial court has
Subsequently, they might have been dispossessed. Therefore, to verify the said fact, we have to go through the evidence.
My humble submit in the record may be called for admitting
No,
this.
Mr. Bora, you say in a routine manner,
Yes.
we cannot admit this second appeal.
That is.
There must be substantial question of law.
Yes.
And what is a substantial question of law has been settled by the Supreme Court in several decisions.
I will satisfy my lord. Evidence that whether section 44 is a substantial question of law or not. I will not get the time. Actually, I went to the native place. I could not time.
Okay,
yesterday.
all right. You can produce it.
Yes.
Next week.
Maybe.
Heard Mr. Bora, learned counsel for the appellant. List the matter on.
First week of the May.
First week
I
of
will
May.
search some citation.
Okay. Pastor comment for further consideration. Further consideration. In the meantime, Mr. Bora, learned counsel for the appellant, shall bring on record the evidence recorded by the learned trial court during trial
Yes.
by filing an additional affidavit.